9 is to for the day as Mr. Borkotoge is no more.
No more. When?
Yesterday evening. So I have to go there. So otherwise, my part is actually.
No. We'll not take it up. Mr. D. Nath, Learned Counsel for the petitioner, submits that the matter be adjourned today and be taken up on any other day. So he submits that the leading counsel, Mr. S.K. Borkotoki, who is leading him in the matter, is no more. So, in view of the above, registry to list this matter immediately after the ensuing puja vacations. I'm sorry. The funeral is over?
No, my lord. Today, the body is to be taken house, my lord. He is at Nemcare.
House is, chamber is here, but house is where?
Now, earlier, presently, my lord, Guwahati Club. Second floor of Federal Bank. There is a Federal Bank.
Federal Bank, that new building.
Yes, BK Towers. My lord, the other related.
All will go. All will go. You inform them, it'll be coming up together.
I'll inform that.
Yes.
5 and 6, my lord. Our paper book is incomplete, my lord. We an adjournment today, my lord.
This is that forest matter.
Yes, my lord.
Come up, we'll see. We'll see.
I beg to mention item number 24 in this case. Taken concern my senior. Small affidavit because a review petition alleged that leadership, the marking in the leadership.
Gador Bormon.
Yes, Lord, I have to reply, Lord, to that part.
We'll have it.
When is the next, my lord?
Will not be possible. Because that is the motion we can, plus we are taking up this old matters. So it will not be possible.
All issue, my lord, only.
But we'll have to hear it. How can I hear it when I'm taking up 10, 15 criminal matters? On the prayer of the Learned Counsel for the respondent, the matter, respondent number 6, the matter stands adjourned. To facilitate the respondent number 6 to file an affidavit in the matter. Such affidavit be filed on or before 22/9/2025. Registry to list this matter again on 24/9/2025. Mr. Ayat Soikia, Learned Counsel for the petitioner, is present. We'll try.
Yes,
Item number 5 and 6.
Me, please, this matter, I was appointed as an amicus man.
Assam Forest. Charges are under 24, 25, 35.
25, 35, 41 of the forest regulation.
24, 25.
24, 25.
35.
35 and 41. 24 is basically, my lord, trespassing. And it is punishable with imprisonment up to 1 year and maximum is 3 years. 25 is felling of trees, my lord.
So here it is, shall be punished with fine which may extend to 5,000 rupees,
Yes.
or with imprisonment which may extend to 1 year or both.
Both.
And 25 is?
Felling of trees, my lord. Minimum is
not
1,
less than-
maximum is 3.
But may extend, or with fine which may extend up to, so this also fine. Then
Fine. Then it's 35. That is the violation of 33. That is also, my lord, regarding felling of trees in the forest land. That is also between 1 and 3 years.
And
And
41.
lastly, 41.
What
that
is your instruction with regard to 41, Mr. Bothagur?
My lord, I'm
Mr. Das, if you read 41,
My lord, is transportation of timber, the forest produce.
the state government may, by a rule,
Ah.
under the laws, that is under 40, Attached to the breach of any rule under that section, any punishment not exceeding imprisonment for a term which may extend to 3 years or fine, which may extend to 5,000. Is a rule filed?
Yes,
Rule is there.
must be there.
That's what.
That is
Whether
why
it
it is
there.
violation of that rule.
Huh,
Prescribed under 40.
40. But where is that rule?
That rule has not been exhibited during trial.
Yes, Mr. Bhattakur.
I've sought instruction, my lord. If there is a rule for 41,
Ah,
movement of timber, my
Ah.
lord.
do one thing. You get your instructions by 2 o'clock. Only on that. Huh? And we have gone through. The witnesses are there. Subject to what Mr. Das says.
My case will be only on the seizure, my lord.
Hmm.
Seizure was vitiated, my lord, because some witnesses say that the seizure list was prepared at the spot.
And they'll say in the
Others
office.
say it was in the office.
Office.
Had their case been, my lord, that the seizure was prepared in the office with proper explanation that their logistical issues were there, then all right. But
There is no explanation.
no explanation.
And even if we now say that that part, okay, we ignore.
Yes.
Still, it is a case under 24, 25, 35 and
41
41. All these cases is or fine.
or fine,
So we can limit it to fine and do away with the.
my lord. Or lordship may also consider the Probation of Offenders Act also. That was also not considered.
We'll not go into that because this is a forest act. I don't want the conviction to go. I want the conviction to remain, but we will, after this 14 years, we don't
Fine.
want to put them back. We will put them in the fine part and let them go.
My lord.
And if there is no fine provided for, we will provide for that fine.
My lord.
Can we provide for that fine in the appellate?
Or my lord, definitely, my lord.
Because we are doing away with the
Sentence, that part.
sentencing.
Yes,
So we will put fine for that.
my lord. That can be done.
You just get that 41 thing.
At 2, my lord.
That too.
Highly honest.
Yes.
Here the conviction is under section 420 IPC. 1 year, my lord.
Hmm.
My first ground is that, my lord, here the FIR was lodged after a delay of 25 days, my lord.
Hmm.
For the said delay, my lord, there is no explanation, my lord.
Okay.
My lord, second is, my lord, the allegation is like that, my lord, the petitioner has taken some utensils from the tent house of the informant. He has not returned. And my lord, when he went to the another tent,
The tenor is that you are involved in such acts.
Yes.
And when you went to Upahar subsequently, you were caught.
but with regard to, my lord, the involvement in other acts, my lord, nobody was examined, nothing is in the record. And my lord, with regard to the owner of the Upahar tent house, my lord, he was also not examined, my lord.
Oh, fine. That is just a reason. The penalty given is
1 year, my lord, 420 IPC. my lord.
1 year. And then you went up on appeal.
Appellate court has affirmed that.
And the appellate court, these issues were.
Appellate court had affirmed the finding, my lord.
So what is the error here?
First is, I have already says, my lord, there is delay of 25 days in lodging the FIR. That is not explained, my lord. No explanation why it was lodged after 25 days.
Did you did you take this point in the appeal? We are only on revision. So was this point taken up in the appeal? We don't find this point to be taken up in the appeal. Where is your appeal memo? So record. How long were you behind the bars?
But I have to check. my lord.
I think you were never behind the bars. Because there was a non-valuable warrant issued against you, came up before this court. This court directed you to go before the trial court, and the trial court then released you on bail. Or you were arrested. Okay, show me that this point was taken.
Appeal.
It was not taken then. Why should we entertain that point today?
But much.
And okay, in the trial, did you confront the witnesses with this issue? Then,
Cross-examination, no.
then from where will we get the answer? You have accepted that position.
Apart from that, my lord, in the 13 examination of the all the incriminating material.
Mr. Barua, just go through how long he was behind the bus. Yes.
In the 313 examination of the petitioner, the 3 questions were asked with regard to PW 1, 2, and 3. 4, 5, 6, nothing was put. So, my lord, seizure not proved, my lord. So, seizure not proved. My submission is that cannot be taken into consideration.
From exhibit 3, my lord. Over from his position, my lord.
Position, huh?
My submission is that since it was not put the petitioner.
When the petitioners were deposing, what is your cross?
Cross to the PW.
3, 4, and 5.
PW 1, my lord.
No, 3, 4 are the Caesar witnesses.
Witness, my lord. PW 2 is PW 4 is the father, my lord. Says, my lord, police come to his house. To the house
Which
of
his
the
son
petitioner
brought for Sada Samani of his father.
and
So and so, so and so, so and so.
two articles, my lord. 1 5
The
plates.
father is saying Sada ceremony of the father itself.
Father itself, my lord. That utensils were brought, my lord.
That we'll not. We'll ignore it.
And my lord, PW 5, my lord, he is the person who has written the Ijahar, and my lord, he is a seizure witness, my lord. And my lord, PW 6 is IO, my lord. All these 3, my lord, 4, 5, 6, nothing was put in 3.
See, the suggestions that you put goes to establish that you had brought the utensils, but you did not have the intention to return it. That was questioned.
That was the question, my lord. But, because 420, my lord, the intention at its inception, my lord. Nothing.
That intention, it can be gathered from the material that the intention was there. You had projected yourself as an employee of the forest department. He is.
The forest guard, my lord.
What happened to his services?
At present, what is his status? I do not know. While filing, my lord, he was just serving as a forest guard.
So he utilized his service particulars for a wrong act, admittedly.
But
Or have you brought on material, record any material to show that these materials were taken for some official function? You have never even argued that, never even pleaded that.
my lord, only one question was put to PW1 that he has returned the goods to the.
Which was denied.
is denied by
Huh.
him, my lord. That is the question put to us, my lord.
So very lenient fine, 1 year only.
1 year, my lord, but my lord, incident of 2008, my lord, and for
And we see that you have been repeatedly involved in this act.
nothing was proved because only in the FIR it was said, but nobody was examined that I have brought the utterances from some other person, returned that. Even the person on whose information apprehended, he was not examined, my lord. My lord, even the utterances recovered, that whether belongs to the PW1 or not, that is not clear, my lord, because he has
Okay, where is your cross to that effect? Where is your cross to that effect? That you question the ownership of the property recovered from you.
that cross
Then-
is not there. my lord.
Then you can't just come and make arguments. You'll have to have some foundation somewhere. And we are in a criminal revision petition. How long? Mr. Gupta, anything more? I'm sorry.
All the incriminating material and recovery cannot be taken into
The,
consideration.
you had induced the PW1 to part with the material because you projected yourself as an employee of the forest department. So he gave you that. But you did not return it to him. It was thereafter recovered from your premises, from your house. That recovery, your father comes and says that no, he had brought these utensils, but for the shraddha of the father. Can we believe that?
That to recovery, my lord, articles were recovered, 5 displated and
One will do. One.
But
But one thing, your father admits to that your defense, your prosecution witness, your defense witness says, no, that goods were recovered, he had brought it, but it was for the shraddha ceremony. And did you, while you were crossing PW1, did you say that this, I did not bring it as a forest employee, but I had brought it for my home use? I've gone through the cross, there is nothing.
there is no inducement, my lord. And my lord, for 420, my lord, only
Inducement is, here the cheating is very large because it's a shop where which they give you, they are there to rent it out. You went there, took advantage, brought it, but you projected yourself as a, for 25 days you did not return it, did you?
the record.
And there is a witness PW2 who saw you taking this matter.
Saw me taking, but he has not, but later on, he is the son of PW1. He says that saw me taking, but only through his father, he come to know that this was,
Fine. He can keep a tab on everything.
he is a, my lord, a repeated witness, my lord.
Yes, Mr. Borwa.
My lord, the evidence of PW4, my lord.
Hmm.
Yes, stated, my lord, that items were recovered from his possession, my lord. But there is no cross-examination, my lord. Apart from that, my lord, other PW1 and 2, my lord, they have 1, 2, and 3, my lord. They have implicated, my lord. Initially, my lord, what happened, my lord? He used to, my lord, take the utensils, my lord. Then he has not returned, my lord. My lord, this news is, my lord, in the Dibrugarh town, my lord. Then from the other 10,000 also, my lord, he used to take the utensils and he never used to, my lord, return. Then he was caught, my lord, on 25/11/2008, my lord.
Incident is of 2008. Oh.
Incident occurred and FIR was lodged on, my lord, 25/11/2008.
So, show me, why should I come in my revision jurisdiction?
First, my lord, the essence with regard to, my lord, that he has brought the goods from the other person returned, as well as, my lord,
Forget it, you just stick to the PW1 thing. That is only to show how you were caught, how you were apprehended. It's only to that extent only. The other things come in. But here, PW1.
W1, my submission is that, my lord, to prove the charge under section 420, the intention at its inception, even if suppose, my lord, I take the goods and I do not return, but my intention at the inception is not to return, that has to be proved, my lord. That is not there, my lord.
No, where is your material to show that I had taken it, but for this reason, it was delayed? You were crossed. The 313 question was there with regard to PW1, PW2, wherein this matter was there that you had not returned it. Where is your clarification? How can you make, Mr. Gupta make that clarification?
But
today?
only one question was asked, my lord, to PW1, that he do not have any intention to not to return the goods, my lord.
Yes, Mr. Borwa, what to do?
After submission, my lord, only 1 year imprisonment has been, my lord, and fine of rupees 1,000. my lord. The revision petition, my lord, the jurisdiction is
But see, it's a case of 2008. Today, 25. Yes.
is filed in the year 2012, my lord.
Because that he had gone up on appeal.
Content finding, my lord.
Appeal was dismissed on 30/5/2012. And the judgment of the trial court is of 2011.
31/12/2011.
11. So,
If I, my lord, only if there is some, my lord, irregularities committed by trial court.
we'll not go into that. We'll only go into that question of probation of offenders act. That much only. We'll maintain your conviction, but we will leave you under the probation of offenders act. Disposed of.
Obliged.
माई बोलने की बात है नहीं हाँ ये सुनिए
Well, it is one of the revision and the findings of the trial court as well as confirmed by the first appellate court.
So what is the error here, Mr.
Basically on 3 points. First of all is that the incident initially, somebody say in the Azhar, somewhere it is written that the incident took place.
1/2/2003
Yeah.
and one says 1/2/2002.
And another says in
That has been dealt with by the trial court itself.
This is the delay, why this delay was occurred. It is more than 35 days delay was there in filing the Azhar from the date of incident. If it is supposed to be taken on 5th of January, that is the 35. It is taken from the 1st of January, then more than. But there is no explanation regarding why this thing was happened. But
Okay.
in the evidence of the main victim, he said that someday delays. And his statement.
That is not fatal to the prosecution.
But so far my client is there, the Mohor Ali. His presence was not there. It is very much supported by the DW1 and as well as my statement also. And moreover,
Okay.
there was
Show me.
no idea.
You had taken a plea of alibi.
Yes.
That you were in Guwahati. Show me the material. to
On
support
that day, well, that cannot be because but the evidence of DW1.
What is it?
DW1.
Hmm?
DW1. No, accused no.
PW.
Accused of DW2. DW2. He's one of the accused, but his name was not there. Later on, he was exonerated for the liability, and she stated
That lady.
My name was not there. Her husband and the
That
victim
lady.
was Yes, lady.
Obiton Nessa.
Yes, she said the husband and the other accused.
They had something. Okay.
And
Okay,
what
what do you want to show?
the findings of the court, trial court?
No, you wanted me to read the evidence.
Yes, yes.
Which one?
The victim,
Zohirul Ali, Islam,
yes,
PW1.
yes.
Hmm.
He specifically stated the Moe Gusor Azharkari Ho on 1/1/2003, ইংৰাজী ইমান তাৰিখেৰ
ৰাতি।
ৰাতি 1টা মান বজাত ঘটনা হয় আসামী ফকৰুদ্দিনে এটা পাণ তামোল হ'ব নেকি তাৰ দোকান আছে মই সেই দোকানত পৰা বাকী খাইছিলো তাৰ পৰা দিবলগীয়া পইচা ঘটনাৰ সময়ত মই আসামীৰ দোকানত গৈছিলো আসামীয়ে পইচা খোজে মই দিম বুলি কওঁ আসামীয়ে মোক মাৰিম বুলি ধমকি দিয়ে আৰু সেইদিনাই মোক মাতি নিয়ে ঘৰলৈ লৈ যায় পোহৰ আৰু ইউনিছ লগ লাগি দা ডেগাৰ ইত্যাদিৰে মোক মাৰপিট কৰে মই দোকানতে ঘটনাস্থলীৰ পৰা পলাই আহি চিঞৰ বাখৰ কৰি মূৰ্ছা যাওঁ This is also contradictory. The other evidence all are saying that he became faint in the house when he reached. But he stated at Dukan, place of the occurrence, I totally fainted. So that is also discrepancy. More Bauhat.
No, he does not say that. He says ঘটনাস্থলীৰ পৰা পলাই আহি চিঞৰ বাখৰ কৰি
Mursa
মুছত হওঁ।
Jao.
পলাই।
Mursa Jao.
Not in
But
the...
he never saying that I reached my home. But the other evidence said that he reached home and there he fainted.
You
So
go
there is a
ahead.
discrepancy,
Go
vital
ahead.
portion there. So again, more বাওঁ হাত পিঠি আৰু বুকুত জখম হয় আসামী ফকৰুদ্দিনে দা দি মাৰে ইউনিছেৰ ডেগাৰ দি আৰু মোহৰে ফালা ডেগাৰ লাইক ৱেপন দি মাৰে হস্পিটালত মোৰ জ্ঞান ঘূৰি আহে কোনে মোক হস্পিটাললৈ লৈ যায় ক'ব নোৱাৰো কেইদিনমানৰ পিছত মই লিখিত এজাহাৰ দাখিল কৰো Exhibit 1 মোৰ এজাহাৰ Exhibit 1 মোৰ সহি চিকিৎসকৰ কাৰণে চিকিৎসাৰ কাৰণে এজাহাৰ দাখিল দিয়া কাৰণ কৰাত পলম হ'ল আজি আদালতত আসামী মোহৰ আৰু পৰিতুন্নেছা উপস্থিত আছে জখমৰ কাৰণে 3 বছৰ কাম কাজ কৰিব পৰা নাই এতিয়ালৈকে মই হাতত বল নাপাওঁ
So that is the explanation.
But the medical report says that his injury was a
He
very
says
simple-
that he was there for 3 years. Medical report says 14 days.
After 14 days, he will be completely recovered.
Fine.
So that is a vast
Pohor.
yes, from the
See.
main victim. He is the
See the cross.
yes. মোহৰে মোক ফালনা দি মাৰে যি কাৰণে মোৰ বাওঁ কান্ধত কান্ধত জখম হয় ঘটনা কোনেও দেখা নাই ঘটনাৰ দিনৰ পিছত 10-12 দিনৰ পিছত এজাহাৰ দাখিল কৰো এজাহাৰৰ মোৰ কথা মতে এজন পুলিচে লিখি দিয়ে মোক কেতিয়া হস্পিটালৰ পৰা ডিসচাৰ্জ দিলে মোৰ মনত নাই সত্য নহয় যে আসামী বিলাকে মোক বিৰুদ্ধে এটা মোকৰ্দমা কৰাৰ কাৰণে আক্ৰোশত এই মিছা গোচৰ কৰিছে so this is a victim he stated is a totally different picture whatever is been supported by the other witnesses
We'll see that. Let's
Yes.
see.
then PW2
So he says
Yes.
that he goes to your shop.
as per his no not my shop I am not Fakhruddin I am Mohar
You're
Actually,
Mohar. Oh,
yes,
sorry.
I am Mohar
You're Mohar.
so I have pointed out that things that this Poritunnesa sees the person as per his evidence that I was there. Poritunnesa was there. The incident took place, and the Poritunnesa
Just come back to the chief.
yes is a PW2
PW1. Third
Yes.
line.
yes
Asami Proputin. তামোলৰ দোকান আছে মই সেই দোকানৰ পৰা বাকী খাইছিলো আৰু 75 টকা দিবলৈ আহি হস্পিটেলত সময় মই আশীৰ্বাদ
মই সেই ওচৰৰ পৰা বাকি খাইছিলো আৰু ইমান
Okay, fine. Fakhruddin is the honor. Okay.
so I was the Mohar
Okay,
my
okay.
name is he
Then number 2,
then yes.
PW2.
Yes. On 1/1/2003, ইংৰাজী তাৰিখে ৰাতি প্ৰায় ৰাতি 7-8 মান বজাত মই মোৰ ঘৰত আছিলো তেতিয়া আছামী ফখৰুদ্দিনে মোৰ ল'ৰা
Fakruddin is missing.
ফখৰুদ্দিন ইজ মিছিং
Absconded.
মোৰ ল'ৰা ৰজিজুলক মাতি লৈ যায় অলপ পিছত হুলস্থুল শুনি মই উপস্থিত মই মোৰ ল'ৰা ৰজিৰুল দৌৰি আহি মোৰ কোৰ্টয়াৰ্ডত আগৰি পৰে মোৰ লগত মোৰ দাদা দানেশ আলী
Ohure.
উপস্থিত আছিল
Me, দেখা
আমি দেখো যে ল'ৰাটোৰ পেটত তেজ ওলাইছিল দাদাই কাৰ্ডটো খুলি দিয়াত ৰাজিৰুলৰ শৰীৰত জখম দেখা পাওঁ জখমীৰ হাত পিঠিত বুকুত আৰু কান্ধত
and this what you call that injuries have been corroborated. Injuries are corroborated by the medical evidence.
But medical evidence says
No, that is different.
the number of injuries is
No,
not
no,
like that.
The injuries that is there, that
Injuries
is
might be there. I am not disputing that there is some marpit, and this has been evidence also DW.
your case is that you are not there and this you are not there.
That has been supported by DW too. That I was not there. The marpit took place between the Fakruddin and the victim. This
Okay,
victim.
let's see.
সেই 15টা মান জখম দেখা পাওঁ ৰাজিজুলৰ যেতিয়া বেহুচ হৈ পৰাৰ কাৰণে এয়া ক'ব পৰা নাছিল মই মোৰ সৰু ভাই অমৰ আলী মাষ্টাৰৰ মোৰ মামা ৰঞ্জুৰ আলী আৰু বহুত কেইজনক জখমীক থানালৈ লৈ যাওঁ আৰু থানাৰ পৰা জখমীক হস্পিটাললৈ পঠোৱা হয় সেইটো 17 দিন মান 16 দিন হস্পিটালত থাকিবলগীয়া হয় লিখিত এজাহাৰ মোৰ ল'ৰাই দিয়ে ক্ৰছ জখমীৰ বাওঁ হাত আৰু পিঠিত জখম দেখা পাওঁ বাকী জখম থাকিলে দেখা নাই only two cross they said only 2 injuries but in the SIP they are saying 14 injuries এজাহাৰ তেওঁ চাকৰি নকৰে এজাহাৰ কি লিখা আছে মই নাজানো এজাহাৰ ঘৰত এজাহাৰখনৰ ঘৰত এজাহাৰ লিখা হয় ঘটনাৰ 3 দিনৰ পিছত এজাহাৰ দাখিল কৰো there is a discrepancy he said that after 3 days the ejar was lost that means it is 5 if the incident took place on 1/1 that if it is his statement is being accepted then that means the ejar was lost on 5 but that ejar was not been brought in the record this is the vital issue এজাহাৰ দাখিল কৰা সত্য নহয় যে আসামীবোৰে আসামীৰ ওপৰত এটা গোচৰ দিছো কাৰণে আক্ৰমণমূলকভাৱে দিয়া গোচৰ দি মিছা সাক্ষী দিছো then he's a father then the another he's an uncle PW3 he is a
PW3 is the doctor.
Doctor yes he's a doctor said
The injuries are there.
But these are the simple
You can
injuries.
come to the
Yes
cross. I cannot say without.
one injury
No.
One card
Page
injury.
3 of that. Page 3 after the Roman 8. After Roman 8, considering the cumulative effect of all the injuries, I open that the injuries are grievous.
Injuries are
Grievous.
grievous, but in cross state it is simple.
No.
Yes, I'm coming.
Let's go down. Let's test it.
Injuries are
Grievous.
only injuries.
Caused by sharp weapon. All the injuries was fresh. The reading this will take some.
But the cross
The injuries could be healed, and the injured could resume his normal
14
work
days.
in 14 days. Exhibit 2. Now, the police accusation for medical examination of so-and-so did not bear the case number, the injuries were 2,
Police examine,
3 hours old, 3 hours old. Whether the injured happened, was hospitalized or not, I cannot
could
say.
not say. So this is of the vital context.
This is only to take you out of 326.
No, my one submission will be there. As per their statement, they said he was hospitalized for more than 10 to 16 days. So after 14
He
days,
cannot say it because that the doctor says how much days he was hospitalized, I cannot say because the records are not.
But they have to prove that I was in hospitalized for 14 days.
Okay,
That
now
is-
let's proceed
that is not
further.
there.
The occurrence took place on so and so at about 9 p.m. I was at the house so and so, so and so.
The next one is another is a relative. The accused placed on 1/1/2000.
Does not say much.
It is on 2003. Now that was in 2002. It is 2.
No, PW1 says 2003
3. It is saying 2002.
and the PW2 says 2003.
PW4 says it is 2002.
What PW4 says it is? PW1 and PW2 says it is
3.
1/1/2003.
3.
Okay.
But there is a discrepancy was there that he said that after 3 days I lost the affair. So that means the incident, the affair was lost on 5. If it is as per this version will be accepted, then where is the gone that 1st January as there? This is not there. So if it is 2 Azahar in the same incident, then if it is not brought the record of the original Azahar, then how these things in court will come to the conclusion?
Mr. Monta, that's why I asked you. You have not read the evidence of the PW doctor properly.
Yes, yes. I have written in the findings also.
Kindly go back. The second line. The evidence of PW1 and PW2 is that immediately they had taken the person to the hospital.
First, police station.
Police station, then hospital.
Yes.
So that is on 1/1/2003.
Okay.
Now you see when the examination is done.
Examination that is on, but there is no police requisition. I am in the year 2003. I was posted as a in a hill office in the PHC and Bokku PS on 5/1/2003.
Ah,
This is also a discrepancy.
that's it. That's what I wanted you to put.
Yes,
And
that
see the
time-
time. See the time.
So the-
See the time.
Yes, 5/1/2000 at about 11:30 p.m.
You missed that out. That's why I brought you back.
No. I listened from the very beginning. I am saying that there is a lots of
Oh,
discrepancies.
Mr. Those two are interested witnesses,
Yes,
but
yes.
the witness evidence is that the person was found, immediately taken to the hospital, at best on 2nd, and he from the police station outpost to the hospital. So it can be either on the 1st or the 2nd.
Yes.
It cannot be on the 5th.
5.
Because there is no explanation in between that he was provided some treatment somewhere else. There is
That
nothing.
is also not. And moreover, the interesting part was that there is no police requisition also. So without police requisition, how that can be accepted? That in respect of the same incident, he was treated in the hospital. That can be accepted as one of this reliable evidence to convict the petitioners under section load, although that is a lesser section. Treatment
Okay, let us see the judgment now.
judgment, yes.
So these are the two major discrepancies you have highlighted.
Yes. First judgment that is in annexure 2 at page 17.
You can ignore the till 19. From
Yes.
para 12 you can start.
Yes, yes. Now the PW1 victim on his father and his father PW2 deposed at the court that the incident took place on 1/1/2003 and PW4 Omar Ali deposed in the court that the incident took place on 1/1/2002. But there is a corroboration in their evidence as regard the time of the incident in the Azahar. That is exhibit 2, exhibit 1. Also date of the incident mentioned in the PW SP 5/1/2003. So the witnesses coming to the depose in the court about after 5 years after the incident, it may not be in their memory in the exact date of the incident. now the PW1 victim deposed in his court that he somehow escaped from the site of the occurrence and fell down unconscious. In PW2, victim of the father also deposed in the court that he saw that is Zahirul coming, running and he falling down in the courtyard, that it is that he saw injuries on the head, hand, back, chest and the shoulder. There Zahirul was unconscious at that time. PW4 Omar Ali reposed in his court that the Zahir came to his house and he saw the several cut injuries on his body. In his statement before the police stated that he saw Zahirul lying on the courtyard, drenched in the blood. However, that the Zahir was seen in the injuries stated on the day of the incident is stated by PW4. Omar Ali in the both the statement before the police and his deposition before the court. Defense also at the time of the cross-examination PW1, victim and the PW2 did not put any suggestion to them and in denial of the fact that the Zahirul sustained hurt on any day of the incident. The evidence of the witnesses also supported by the medical evidence on record. From the discussion made above on the evidence on record, it is held that Zahirul Islam sustained hurt on day of the incident on 5/1/2003. Now it later determined whether the said hurt was grievous. Medical officer PW3 deposed in the court that he opined that the injuries were grievous, and during his cross-examination that none of the injuries were grievous. In cross he stated, doctor. Also,
Exhibit 2 is the medical report.
yes,
Let us just see what that is. You have that with you?
I have not that copy with me, but the so far this but copy is there. Put together 8 injuries in there.
You have the medical report with you?
This is only the position part.
Deposition, not one day report, exhibit 2. Page 20.
One another vital aspect also there.
Just give me 2 minutes. Mr. Monto.
Hello.
Kindly take your seat for a minute. Mr. Borba. Incident is of 1/1/2003. The PW1 and PW says that PW1 was unconscious. PW2 says that he came into the courtyard, fell down. She raised the halla. Neighbors came and he was taken to the police station. From there to the, what do you call that, hospital. So the hospital examination will be on 1/1. Huh? But the deposition of the doctor is that he examined the patient only on 5/1. So factum of the incident gets diluted. And I wanted to see whether the exhibit 2, which is the medical report, is of 1 or 5. It is of 5.
Verify one.
You check up the check up the evidence of the doctor and the date of the incident. Other 2 discrepancies, Mr. That 1/1/1 to 2002, 2003, it might be a slip up. But this is something
This
which
is very important, and moreover, they are saying that the Azhar was lost in the something used to be there. At least GD entry should be there. on the data, without police requisition, how he could be examined in the
No, no,
court?
there was a police requisition. You see,
So doctor said that there is no.
no, 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 there was, he was
If
forwarded
there
by
is
the police.
requisition, where is that record?
No, 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 there is a police thing.
As per the
And
evidence.
there is material. Have you got it?
In cross there, the police requisition for the medical examination of the did not.
Have the number or something like that, but he was given by some police only.
Not been, it is written like that, the case number. Case number was not there.
No, case number was not
Yes,
there,
yes.
but he was sent by the police only.
The police, but if something was there, the police has to brought this
Oh,
record to the court.
Mr. Why the gap of 4 days?
My lord. It is of
One.
5-1,
No.
5-1.
No, 1-1.
Now, Lordship may kindly see the FIR, my lord. FIR, my lord, that
FIR is of 10/2/2003.
was on
10-2.
10-2, my lord. Because, my lord, the
Finity
5-1
Nibejan AJ Moore pass okay.
5-1 incident occurred, my lord. He remained in the hospital for 16 days, my lord.
Okay, now it
After
for but
the 4 days,
that 1-1. Okay, fine. Sorry. Okay, I got it.
And
Yes, Mr. Monto.
No, this is true. They have written this as their incident took place on 5-1, but their evidence they are saying what? They're saying they're 1-1. Evidence has to go.
these are minor discrepancies, my lord.
How
We have
that
to
can
go-
be?
We have to go by the
Two witnesses,
statement
not
of the
only
victim,
one.
my lord, corroborated by the medical evidence, my lord.
Now,
And
now
for-
just check up. This information was given to the police on the same day, 5-1 itself. Just check the GD entry. The FIR, the case records, the case diary, I think is towards the
Did
end.
not carry any GD entry. In the so far, my record is there. And there is no any exhibit also to that effect.
Okay, Mr. Monto, these two dates that were given 1-1, that's error because that's not a major thing. So 5-1, the incident, and 5-1 itself will have the clarification from Mr. Borua about how the police could accompany him.
My submission is this, my lord. The FIR or SJR, that is the first information to the some incident occurred, my lord.
No, we'll come to that.
So this
What
is the
about your
vital-
alibi? What
Yes.
about your alibi?
alibi was that I was not there. This is the my
What is the material to?
material.
No, not material that you give him some ticket or
But
something.
no.
I'm not on that.
No, if the court will go by the circumstantial evidence.
I'm
then if
coming to that only.
Yes, well,
I'm coming, Mr. Monto, I'm coming to that.
that has been supported by the W2.
Give me 1 minute. Did you, during your cross, put a suggestion or a question to the PW1, PW2 that what you are saying is wrong with regard, because I was not there. Any cross to that effect?
But the DW I have specifically stated in my, yes. Lordship come to the judgment.
You read it?
Yes, well. This page number, it is continuous page 21. Here DW2. DW2 Paritun Nessa deposed in the court that the Zahirul at the about 12 midnight went to her house thinking that her husband was not at home, that he could hold of her husband thinking to be her. The assault took place between the Fakhruddin and the Zahirul with the lathi, that therefore Zahirul was.
This is DW2.
Yes, he's a wife of this main accused, Fakhruddin. And moreover, the next my DW1, this is
Is it there?
Mm,
Mr. Borua, something?
No, my lord, I'm just trying to get the GD&T, my lord. The CD, complete part of the CD is not here, my lord.
and
The
DW1,
requisition, police requisition is there for medical examination. Because a policeman accompanied him. Do one thing, you go through it, we'll take it up after some time.
but that was not exhibit, my lord. My submission will be there.
Just to get the
Yes,
things
yes.
in the proper perspective.
Lordship. Lordship have to be satisfied in for all respect, my lord.
Because this is an appeal, I can go into the.
Yes, it did.
I can
But there is a
reappreciate
revision,
the
the
evidence.
limited jurisdiction. I know, your lordship. But this is why I pointed out that there is a two vital.
No, this
things.
is a revision only.
Yes, sir, that is why the limited jurisdiction.
Limited jurisdiction.
Yes, yes. That is why I pointed out to try to point it out this only.
The incident is of 2003. 22 years. Okay, we'll take it up after some time. Mr. Borua, kindly get that difference
After some time.
after some time. If you have any other matters, you just do it and come back. Item number?
12 and 13.
Number 39, my lord.
Then 10/2/2003. That is the first information received. And a GD entry was made. So, Mr. Monto,
Hello.
then you take up the evidence of PW, the doctor.
Yes.
If the first information, forget the GD entry, first time police came to know on 10/2, how come on 5/1,
Legal. Medical.
when the Jahirul was forwarded to the
PHC.
PHC, the police had forwarded him?
After that, my lord, he was the hospital, my lord.
There
Till
has
then,
to
no
be,
FIR was lost, my lord.
no, no, there has to be a GD entry because the police is accompanying. Without a GD entry, how will a police accompany?
If their statement is there, I did too.
If you can satisfy that 5/1 thing, the rest will fall in place. That is the odd man out now. Mr. Borua, don't rush, you go through it. We'll have it at 2 o'clock.
Well, well.
2000.
12 and 13.
We'll take up 13 first. That's the appeal against conviction.
Appeal, not a conviction, it is against
Lower
for
punishment.
enhancement of the sentence.
But there is another appeal by Moniruddin
Yes.
against the conviction.
They are fine.
You argue that first. Let him argue. Yes, Mr. Das.
Here, my lord, only in my case, my lord, only, my lord, conviction was only 147 and 447.
147, 447.
Yes, my lord.
To cut the matter short,
Yes, my lord.
you were identified by PW1, PW4, right? So the other things had gone. So it was 447 rupees 500
Yes,
and 147 rupees 2000. What is the error?
I'll paid.
Mr. H. Das, Learned Counsel for the appellant.
Appellants.
Appellants. After attempting to argue, after having argued the matter at some length, submits that he would not press the present appeal and the fine as imposed and the conviction as and their conviction by the learned trial court void the judgment and order dated 12/6/2013 be maintained. He further submits that he would also not question the sentencing as awarded by the learned trial court and would comply with the same. Accordingly, in view of the above, the present appeal stands dismissed. Now, Mr.
But I have come for enhancement of the punishment. Initially, case was registered by the police, my lord, under section. I mean,
You are Jamila.
Jamila,
Now,
informed.
first tell me, which is your house? There are two houses there.
Both the houses belongs to me, my lord.
One is your father's house.
Yes.
This is your this thing. There
Just
is
like fire.
there is an enmity.
Yes, that is established.
That is also established here. There is a case already pending. So the other accused, you have now preferred this against
All the accused persons, those who have been convicted. Moniruddin and Gulab Ali,
3, 4.
four,
Moinuruddin, Gulab Ali, Nurul Amin, Habez Ali, Sorab
and
Ali.
Surab Ali.
Why not the others? You said there were 50 or 60 people who had
But
barged into your
the
house.
court has come to the conclusions of these 6 persons.
You, in an appeal, you can always,
And I could have.
you
I could
should have.
Yes.
So that gives rise to the fact that this is just a continuation of the earlier burning.
But there is a 395 also, dacoity.
Dacoity, but dacoity elements have not been proved. Show me.
What court
The
has
court
come to
has
conclusion?
made a categorical.
Yes, mentioned that.
Okay, 5 are there. 5 persons are required for a dacoity.
Yes, that's a more than 5.
More than 5. So at least 5 we have.
5 we have.
But,
395 could have been applicable, madam.
what is the exact wording of 395?
More than 5%.
More than. But you have only 5 now.
Yeah, 5, more than 5 means 5 includes more.
No. 395.
5.
And 5 or more.
5.
So, but here the materials that are the learned trial court has specifically gone into that issue
you
and
can
have
find
returned
any
a
material
finding that 395 is not
not
attractive.
there. That's why it has been court has not convicted them.
What do you have to say on that? What is the material to?
But actually, the evidence portion I don't have. That's why.
Then we can't help it. Because I think the conviction is there now after 20-25 years. The incident is of?
Incident of 2013. Earlier, 2010.
No,
2010.
So another 15 years have passed by.
I leave it to your lordship.
No, Mister, if you're not pressing it.
But had there been a material that is regarding evidence matter, portion matter, if your lordship peruse it, matter, your lordship will get some material matter.
It's all vague. The direct evidence is of PW1 and PW4. The others have not even identified the accused.
Even 2 persons could identify when there are 2 persons.
1 and 4. And 1 and 4, along with that, there is a material that they are having that enmity.
The court has come to the conclusion 147, 447. That given an implies opinion, my lord, should have that they were the party to the whole incident.
No.
Dacoity and my lord.
Dacoity, there was something here because Moinuruddin in his deposition had said that he had demolished the house.
Then?
No, not here. In a civil case. And it seems that there was a land dispute.
Yes, that has been established.
I think after 25 years.
That is a different issue, madam. That should not go to
We will
after
maintain.
25 years.
We
There are
will,
judgment also on that.
we will maintain this penalty and we will close this matter.
Of life.
We have dismissed this appeal.
Yes.
We'll dismiss yours also. Let that be rested there.
40.
Yes, Mr. Mishra, you found anything?
Yes, my lord.
Hmm.
But, here, section 13(2) notice
Hmm.
was sent by registered post.
Hmm.
Now it reached to the.
That is a presumption.
My lord, that
General
presumption,
Clauses Act.
my lord, that matter was dealt with by this honorable court in 3 judges bench,
Hmm.
and thereafter it was nullified by the Supreme Court itself, saying that the
Right.
purpose is
Prevention of Food Adulteration Act. 13?
13(2). my lord.
On receipt of a report of the analysis, so and so, so and so, so and so. After institution of prosecution against them from whom the sample are taken and the person, if any, whose name was under section 14A, forward in such manner as may prescribe with the report of it. Okay, what is that decision?
Can you take it? The first decision of 1993, 1 GLR, ma'am.
Hmm.
It is 3 judges bench, my lord. Your lordship may find the finding at page 24, my lord. Paragraph 24. my lord. The paragraph 22 says, my lord, drawing a presumption in a criminal proceeding is not uncommon. Relying on that, my lord, paragraph 24, the local head, it starts as local
Hmm.
health authority, is a
Hmm.
public official.
Hmm.
The act of the local authority independent in dispensing the copy of the report to which necessary intimation or information is an official act. When the act has been shown or have been performed, it is open to the court in its discretion to draw the presumption that the act has been performed regularly. If there is acceptable evidence to show that local health authority has forwarded the document by virtue of illustration E of section 14 of the Indian Evidence Act 1982, the court may presume that it was forwarded regularly, that is as required under section 13(2) of the Act.
There can also be no difficulty.
There can also be no difficulty in invoking section 27 of the General Clauses Act
Hmm.
in appropriate cases to
Hmm.
draw appropriate presumption.
Hmm.
That has been dealt with by the Supreme Court.
Hmm.
The case of Ourango Sahu, reported in 2014-13 SCC,
2000?
2014-13 SCC, page 80, paragraph 4, I
It is on record. You have given me a copy.
think I have given the list. I will provide the report.
No, it's okay. It's okay. We will have it here also. No problem.
It is the copy. Paragraph 4. Paragraph 4, my lord. It is argued on behalf of the accused, Lordship Botman. Mere dispatch of report is not enough, and that the presumption is to a presuppose prosecution is further obliged to prove that the letter of dispatch had reached the addressee or the accused. We agree with this submission, as we believe that forwarding a copy of report is not only a ritual but a statutory requirement to be mandatorily observed in all cases. Dispatch of such report is intended to inform the accused of his valuable right to get the other sample analyzed from the central food laboratory. Here the postal receipt was, confirmation was given, so it was accepted.
Hmm. Hmm.
So thereafter, my lord, 2004 by this honorable court
Hmm.
has held that is mandatory. 2004, 1 GLT 667.
Hmm.
Relying on the Gauranga case, my lord, paragraph 4, 5 and 6.
Hmm.
Then 2005 supplementary GLT 764.
Hmm.
A long judgment, my lord, number of paragraphs has discussed about the Gauranga case, my lord. Paragraph 16 specifically discussed about it. And paragraph 21 says specifically this presumption which can be raised under section 27B of the general clause is, however, rebuttable presumption. Non-compliance was
Just a moment.
Yes.
Just a moment. Give me 2 minutes. Got it. Now you come to the material.
my lord, there are other judgments are also there, my lord.
We'll go
My
to
lord.
I think this is latest one.
So my latest by
2020.
yes, my lord, Supreme Court.
What is that?
Here also, my lord, trial court held that paragraph 8 sub.
Hmm.
The postal receipt was there, my lord.
Hmm.
It was not proved whether it is reached or not.
Hmm.
And accordingly, it was decided in paragraph 15 and 18, 15 or 14, my lord. It starts on receipt of the matter, my lord. I have got
On this aspect of the matter.
on this aspect of the matter, that is paragraph 15.
We take note of it, so and so requiring to furnish the report.
Learned judge have, however, failed to take. Starts from there.
Okay.
Finally, it was held that very fact, second but last paragraph, my lord. Finally, it held that the very fact that the analysis report being served not proved would be sufficient to hold that the prosecution has not proved guilt of the appellant beyond reasonable doubt. And the conviction is not justified. Now we will go by judgment, my lord, of the trial court.
Hmm.
Number in lordship.
As far as I understand, that it is sent under 313(2),
Yes,
that notice once it is sent,
yes,
that the accused has to now come up and say
yes.
that this notice has not been. Then the onus will shift. They'll have to now, that presumption is gone, they will have to establish. Now show me from the records that the accused or the petitioner here had raised this. Because nowhere I find that the 13(2) question had come up before the trial court.
Paragraph, page 19, my lord.
Hmm.
Straight away I am coming to page 19. my lord.
Hmm.
The last part of paragraph number 9.
During cross-examination.
Just few lines before paragraph number
Okay.
10, my lord.
Hmm.
The witness also proved exhibit 15, a copy of the letter issued by the local health authority. Lordship,
Hmm.
A.C. Sharma under section 13(2) of PF Act 1954. Exhibit 16 is a postal receipt. During cross-examination PW1, it was not even suggested that the said accused person did not receive the copy of the notice under 13(2). That is there. Now, two witnesses are examined, but not the accused. Persons who have
TW1, one is that
they said
person,
that the article, that means the milk, was purchased from a person,
no warranty given,
no warranty given,
no disclosure,
things are there.
nothing,
but as regards the issue of notice, there is
nothing.
no specific mention.
So if that is not there, you can't develop it afterwards. Can you?
Yes, that has been addressed by this court, my lord.
That much you show me. Because that notice was not received, has to come up before the trial itself, in the trial itself. You have taken this plea in the appeal, but the basis is not there. Now show me to that extent whether we can go.
Here in 2004, 1 GLT 667, my lord. The learned trial court marked that notice as exhibit X, but no proof to that whether it is served to the person or not.
No, here 2000, you are referring to 2000?
2004 1 GLT 667.
That plea was taken.
There is no discussion about that.
Mr. Bishop, this has to be established or said in the trial.
But that,
Because that presumption, once you accept it, that is then that presumption will drop. 13(2) presumption will follow. You have accepted it. Because he exhibited the registered post. You did not say that I did not receive it. That much evidence should be there.
but that
Or the cross that this is wrong because I had never received it, either in 313 or somewhere. Any material.
But here, my lord, I've gone through the evidences, my lord. But here, my lord, these judgments I have placed, my lord. No
You come to
discussion on
20,
that.
that latest what, 2020. Come to paragraph,
In the instant case, paragraph 14, subject to correction, my lord. The contention put forth that firstly, no such report of analysis has been made available to the appellant. There is no proof of delivery of report.
no. Para 7. Before the trial court.
For the trial court,
It was argued on behalf of so-and-so, they then supported. The appellant further alleged non-compliance with the provisions of section 13(2) of the so-and-so regarding PW3 so-and-so. Regarding compliance with the so-and-so, the court held that compliance is clear from the statement that the report of so-and-so was sent to the address of the appellant through registered receipt dated 7/4/1980. Now, he disputed it. So
Yes.
the presumption was not there to be taken. The proof has to be brought on record. That was not brought. In your case, and my Lord Justice Ansari's judgment is very clear that it has to be, it cannot be a general proposition. It has to go case by case. Now here, what I have understood is that presumption is there, but it is rebuttable.
Yes.
You can rebut it. Moment you rebut it, they'll have to show that no, the actual service was done on so-and-so and so-and-so date.
In another case by the Honorable Sorry, my lord, that is criminal revision petition 732, I think.
Now, the plea that you have taken, Mr.
Yes.
But the problem here is what I'm just trying to formulate it. If this issue is not taken in the trial, the other side will not have an opportunity to rebut it. That no,
Yes.
we'll prove it. They can produce further evidence saying that, see, this is the date when it was served on him. Now, you go up on appeal, they don't have that scope.
But,
You come up on a revision, they don't have that scope.
but after that, my lord, no exhibit has been produced and no evidence led to the event that.
No, need not be,
Sir.
because you have not disputed that position at that point of time. Let me see. Yes, there is material. In his 313, there was a question put to him. উক্ত পৰীক্ষাজনৰ আৰু LHA PF or Act 13(2) দ্বাৰা মতে পাব্লিক এনালিষ্টৰ ৰিপৰ্টৰ কপি সহ নোটিছ ডাক যোগে পঠাই আৰু উক্ত নোটিছ আপুনি পাইছে বুলি কয়। আপোনাৰ জবাব মই পোৱা নাই।
Then that is there.
Oh, but
My lord.
okay, fine. There is that presumption. The learned trial court ought to have considered that. And it could have given you an opportunity.
But lordship, in this aspect, my lord, lordship may kindly read, my lord, paragraph 9 of the judgment, my lord. Judgment of the trial court. Let go.
Paragraph?
Paragraph 9, that as I have.
That last line, witness proof so and so did not even suggest. Okay. Anything more? What is the punishment?
6 months and 2,000 rupees.
No, under the Act. Punishable under section 16.
Nay.
And with fine. Yes, what do you have to say here?
My lord, my humble submission. It 15 was the notice, my lord. Now, in my lord, prevention of
No, there is, because see, that notice is not just an empty notice. Like in the drugs, that Drugs and Cosmetic Act, when a sample is drawn, it's made into 4 parts. One is given to the lab, the other one is given to the person from whom it is drawn or the manufacturer, and the other 2 is retained. So when the report comes, because there is a time frame for that. Here also there is a time frame.
my lord.
Not very conversant with this act, but the Drugs Act, there is a time frame. Within that time frame, the drug has to be examined and its report has to be given to the party. Now the report has to be given within that time frame so that within the date of that, what you call that word used is not validity. When that drug is active, when the drug is, because after some time,
Yes.
the drug becomes bad.
Yes.
So within that time, he will have to have that information that that sample is gone against him. The dissolution test, all those tests have gone against him. So that he can make an application to get the other sample checked in another laboratory,
FSL, my lord.
wherever.
Yes, my lord. Yes.
Sometimes it's done in CFSL also.
Yes, my lord.
So here also, he has that opportunity. Public analyst has given him, he can go before the Central Forensic Science Laboratory or wherever it is under the Act and get it. So that's a vital right. And that is why the Supreme Court has said that this has to be established.
Now, my lord, as prosecution cases that, my lord, fight exhibit 15, my lord.
That will
notice-
not do because now you come to the appellate order. Appellate order at page 32, para 9. Here it says because the registered letter was given, because it was a specific point taken in the appeal. that say this notice was not received. So I was under the impression that there was no basis. But anyway, 313 statement is there. So that has to also be given some credence by the, it cannot be ignored. It's not an oath statement, but when it's a technical issue, it's a technical thing, procedural thing. The trial court ought to have given it. On that count, we are.
I humble submission, my lord. At exhibit 16, my lord, we have sent a notice to the, my lord, accused person, my lord. Now, my lord, the owner safe to the accused person, my lord. To
I got
prove
it.
That the aforesaid
I
notice
got it.
was
If there was not even
served
that,
or I have not received, my lord. Maybe,
That-
my lord, it was sent, my lord, but I may not receive, my lord. That is a different aspect of the matter, my lord. Now, my lord, before examining, before his reply in 313, my lord, CRPC, there has to be some evidence, my lord, during the cross-examination of the, my lord, PW1 and PW2. Basically, PW1,
no,
my
that
lord.
313, that statement.
313 comes, my lord, after.
No, I'm not with the prosecution, not with the prosecution. 313 comes after the, but it was before the trial court when it passed the judgment.
My lord.
It has not even considered that.
He has taken a plea in the 313 that, my lord, he has not received the, my lord,
Notice.
report, my lord.
Mm.
So that, my lord, he could not appeal or he could not, my lord,
No, he did not say anything.
yes, my lord. But
Point
there has,
one nine.
there has to be some cross-examination. There has to be some cross-examination, my lord.
We'll
A
consider.
part of PW1, my lord.
We'll consider.
And, my lord, the notice sent by you has not been received by me, my lord.
We'll consider.
My lord, regarding this aspect, my lord, the Supreme Court has clarified, my lord.
Yes, give me.
2020 15 SCC, my lord,
2020 15 SCC.
763, my lord.
What is this?
It goes in favor of
Yes,
him,
that-
my lord.
No, please.
So that is why, my lord. Vijendra versus State of UP, my lord. Vijendra versus State
Yes,
of
I have placed it. That is
2020.
Yes, yes, I have placed.
Oh, that Vijendra.
Vijendra. Yes, that
Vijendra
is-
is in his favor.
That goes in his favor, my lord. There is a procedure laid down by the Supreme Court, my lord. What is the requirement of my lord? Furnishing the notice under section 13(2), my lord. So that accused, my lord, his
We'll
right
follow
has
that.
been-
We'll follow that. We are interfering with the conviction and the penalty, both. Thank you, Mr. Mishra. It's been a learning experience.
So to my. This is my past case. So I can feel my.
I have done one matter in the Drugs Act, but here I have not. This is my first. Okay, fine. Thank you.
Regarding that issue that.
Both
the-
of you. Hmm.
The articles may decomposed or something like
But
that.
this case, I'm coming in your favor, but I'm of the view
Yes.
otherwise, because I'm bound by to follow the Supreme Court judgment. I'm following it, a High Court judgment. But this foundation has to be laid in the trial. Without that, it will not
That
be.
is what, my lord, my submission, my lord. Before he take a plea in 313, my lord, there has to be some evidence.
Some
my
in
lord.
the some
Cross
foundation
examination
has
of
to
my
be
lord.
laid in the cross.
Or, my lord, he can adduce different evidence.
You can give him a suggestion that this thing what you have said is wrong because I have never received this notice. Get a reply, then he is bound to. Then we can ask him, why have you, that presumption will not be there. The presumption is gone. He will have to adduce. Anyway, this case we are leaving it. But we'll remember this for the next matter, some other case.
Thank you.
Yes. Dispose of it. Yes, Mr.
My lord.
Very serious with the conviction. 411.
My lord. No,
Hmm?
there is.
Very
Yeah.
serious with the conviction. Are you very serious with the conviction, Mr.?
My lord. Yes, yes, yes.
You're serious?
My lord.
Okay, then we'll hear you.
In the practice, there are 5 PWs, my lord, and including the IO and informant.
Item number again, 15.
15. Some goods are lost.
Mr. The theft is not proved against you, right?
That is, my lord, only, my lord,
But you have not dispelled any of the evidences wherein the recovery was made from your house and the trunk was recovered from the Nala.
Nala.
So 411.
11, but one thing, my lord, everyone, my lord,
It was admitted by me on the threat and assault. They assaulted me and also.
Show me the cross.
My lord, yes.
Yes.
PW on. Yeah, I did.
PW?
PW one, my lord. He is the informant, Rafiqul Islam. More Gosaro assignment.
Just a second, Mr. This is. Mr. Goswami, have you gone through the evidences?
Regarding the, my lord, position of article as per, theft did not prove because.
Yes, what is your material? সত্য নহয় যে মই ইমান তাৰিখে ঘটনা হোৱা বুলি এজাহাৰকাৰী উল্লেখ কৰা কথা মিছা আৰু পুলিচৰ আগত কোৱা কথা মিছা সত্য নহয় যে মই পুলিচৰ আগত মোৰ কাগজত লৈ থকা নাই. Okay, what do you want to say? Cross.
Oh, yeah, Gosaro.
No, you can come to the cross. He has said many things. I want you, how you have this.
No money receipt or receipt that was given.
Oh,
Those are
that is too much.
Yes.
That is too much.
Yes.
That is too much.
Raizor মানুহে আসামি মারপিট করিছু তার আসামি
That is also there.
admitted, yes.
That is what once you have,
And he has admitted.
because you were found to be a thief.
Thief.
And the learned trial court has said that they have exercised their right under section 43, the public. And if there is not a little bit of pressure, will a person come up and own?
Not the person who they have been entered in my house after 12 night. So how that
They are people. They are rise. Rise is the king
public they
in a
can-
democracy. Now show me how you have disputed that. Mr. Rashid,
Well-
something is there. You put it to the victim that you have not said these things before. The PW not said this before, the police not said this. So this is not recovery by me, that. Then you take it to the IO and get it confirmed. I don't find that thing here.
the goods which
I
are-
can do one thing for you. 411
11.
has two parts. One is the imprisonment, one is the fine. Maintain the conviction to the fine. After
And my lord, your
this is of incident is of 2011. After 14 years,
as a ETI Miller, I was Miller in jail for about Miller 3 months, 4 days. As it is. So that
Okay.
person Miller, it will be converted to that Miller.
we can do that also, but confirm that for me.
Yes, but
On
there
the
has to be,
record is there Miller. I have also
My lord,
found Miller.
because
He was in jail Miller as a ETI
he
Miller.
was granted
3 months, 4 days.
as per the
Arrested
order-
when?
Arrested
As
Miller.
on 8/9/2011, once
Yeah.
first arrest, 8/9/2011.
Bail?
There is a order of the High Court, my lord, granting bail on 21/8/2013.
No,
But
that is after the.
After the, but
After
in
the
between
judgment.
he was, perhaps some months he was.
How long?
In
That
my
you will-
calculation,
just take up.
The record is there.
Find it.
Record. In order process.
I could not find out my regarding that part is not there. I have seen my lord.
No, the
Court order, court order.
CJM records, there
Yes.
will be an order for bail or something would be there. You let me know, Mr. Either that or we are maintaining the conviction, either to the extent if you have gone for 3 months,
There is a conversion, maybe it may be
we
converted.
will put it fine.
No,
What has
let it
happened?
Let it be on, because yes, because 1 year it is,
Honest
if it's 3
conviction.
months, my lord, that can be or fine. That is. But fines has to be some, because
A fine has to be increased.
fine has to be increased if it is.
Okay, done.
Yes.
Conviction maintained, don't go to jail. After 14 years, we don't want to send you to jail. But give me that. I want that also. Just write it on a piece of paper and give it to her. Dispose of. Hmm.
2003 incident, Lordship.
Here, in this case, don't start with that. You're not getting that benefit here. Every case that is not going to come.
That is.
3 fingers gone.
No, but
2 fingers gone. Attack. Scene.
what is the evidence? The person who said that he had lost his fingers, he himself had signed in the exhibits. That is the evidence, which is.
Oh, he's an expert.
He is.
And see, there is a finding recorded. There is a observation of the court that he himself, the court has seen it.
And also, Lordship.
It is there.
Yes, yes.
And also, Lordship, he was admitted in the hospital. That is also on the next day only. If the incident is so severe, then possibly he would have to admit it, because he was surrounded by many persons. And there are many other discrepancies also regarding the evidence which I have stated in my petition, and have also taken the grounds, Lordship.
Amputation of index and middle finger.
And medical
Yes, ma'am.
evidence is also that can be by falling down on a hard substance. That is also there in the medical evidence. The evidences of PW 5, 8, and 9 are important, Lordship.
Okay, let us see.
Yes.
You have a paper book.
I don't have, but I have the evidence, PW's evidence.
Okay. You want me to go to?
PW 5, who has stated that he had seen him himself sign in the exhibits.
Five. 5 is Bishwajit Kumar Shil.
So examine, it's a cross, Lordship. I do not know the exact time of the occurrence. Exhibit 1 was prepared at Udharban police station till 1:30 AM. No medical treatment was given to Anjan Chanda. Anjan Chanda put his signature on Exhibit 1. He put his signature by his right hand. I do not remember the name of all the signatories of Exhibit 1. When I arrived at Udharban police station at so-and-so, there was about 25-30 people at the police station. These people were from neighboring area of the place of occurrence. I do not know what is written in Exhibit 1. So if he had lost 2 of it, it's not at all possible to sign.
Madam, that statement that you are saying, I found somewhere an observation of the court.
That was immediately about at the time of incident. The court observation may be only at the time of.
Where was that observation, Mr. Goswami?
There is an observation regarding omission. That part, my lord.
No. That he had seen the hand of the victim.
In Cesium's on court's order, my lord.
Oh, in the court's order, somewhere I found it. Yes, Ms. Sharma, did you get it? Yes, internal page 4. Yes. Have you got it?
Lordship.
Third line, I have had the occasion. You get it? To observe Finder so and so in the presence of the learned and the learned defense counsel and our sub-observation, I find no reason to doubt the medical evidence. So anything you say with that will have to be, we'll test it in this. And this is a
Appeal.
appeal. Okay.
Secondly, what I want to.
No. This is just the preliminary hearing. Now the main hearing. Now tell me what your points are.
Lordship.
This is just to update you on the views that I have drawn. Tentative.
First of all, Lordship, there was no motive or intention because the
No
PW
motive or intention. So the next question would be, when there is direct evidence, whether the question of motive would come in, would be required. When there is direct evidence. Then if that be so, subject to correction, there are experts here, then no criminal case can be.
it
No
is stated
criminal
by the
case can
person
be,
present that
it's there will be. But in every case, if the court, when there is direct evidence, and still the court has to prove the motive, I don't think so any criminal case would be proved.
Yes, ma'am. There is an answer to that in PW7's my lord statement, my lord.
Okay, we'll come. Yes.
So, Lordship, regarding the lodging of
No
Eja-
motive and or intention.
Yes.
Then
lodging of Ejahar, etc., Lordship, PW2 stated that he had informed the police, but as per PW3, GD entry was made after his intimation to the police. Although incident took place in the evening 7:38, the persons were not admitted in the hospital, and only from the evidence of IO that on the next day only they were sent to the hospital. And some other person who are along with the petitioner, except one, the others were also not examined. They are Fajan Sahu, the driver of the vehicle.
no,
where-
one by one. Next one.
that some of the vital witnesses were not examined.
Vital witnesses. Not examined. Who were with the victims?
Yes, the driver and another one.
Who were present? Then
Then there is a contradiction regarding the picture of the scene, that where it was happened, who were present, etc. among the PWs.
contradiction with the exact place of occurrence.
Yes.
Then
Lordship, although it is their case that the other person was also injured, but from the doctor's evidence, and there was no entry, etc. of the other persons. And doctor evidence is also.
only here this is with regard to that brother, second Anjan Chanda.
And there is no medical legal, those X-ray, etc. were also not produced. And doctor's evidence is also that, Lordship, this type of injury can be of Lordship. I am.
Where is that?
PW9. PW9 in his cross have stated that such types of
PW9.
yes, then first paragraph, last line, the injury sustained by patient number 1 may be caused by fall or by dashing on a hard substance.
That is with regard to one, that is
Milan.
Babla Chanda,
Because
not Anjan
No,
Chanda.
no.
Where did you read it?
this cross-examination.
That is patient number one.
3 persons were examined by him, my lord. Milan, Babla, and main.
There was
Because-
one hospital number for patient number 1. So he,
One, under that, all these three were examined.
Examined.
But Ms. Sharma, this doctor, he has given a separate report with regard to the injuries sustained by Anjan Chanda. That is not disputed. And injury number 3 is this cutting of the fingers, amputation.
Index and middle.
Now, when is the date of this examination? 24/12. So and so 1:45 p.m.
was 23,
23rd.
23 to 12. I also stated that he had admitted only on the next day.
23rd, that is in the evening part. Evening part, that is in 7 to 8.
But madam, see that 3. See 3.
On the same day, I also examined Anjan Chanda, son
A
of.
clear amputation through how was this person's treated in between?
No,
What is the material?
that was also asked that there was no, this is very much,
Huh.
Your Lordship, there was no mention, Lordship, there is no mention in Exhibit 5 that the injured person were earlier treated by other hospitals. So there was no medical report that they were treated. And I was stated they have admitted only after I visited their house. The person was very much in the house. Lordship, I was.
So it would have been bleeding, he would have been dead
Yes,
by now.
Lordship, that is.
Thereafter, it is on my lord, night, my lord.
Huh.
7,
Next
8.
day,
Next day.
the examination is at 4:45.
Next
He
day.
went to
1:45.
sign also.
4:45. Doctors,
Yes.
I examined one patient at 4:45 p.m.,
Yes.
namely Babla Chanda, and then followed by Anjan Chanda.
Yes. There may be some first aid or something like that. That is not in the part of the, but
No, the finger was cut off. So how can he be without treatment? There has to be some explanation somewhere.
cannot disbelieve the evidence of the doctor. That
We are not disbelieving it.
Yes.
But the question is, if the whether this was caused on the previous day, as alleged in the FIR, or on 24/12/23.
Because in the FIR it is 23rd.
23rd,
23rd.
night.
23rd.
Yes.
Night.
So, if it goes within a few hours, then the injury can be said to be fresh.
Yes.
This is more than after 12 hours,
23rd. Yes.
18 hours.
Yes.
How can the injury be fresh? That is the, okay.
Lordship, this will corroborate the evidence of PW8.
Hmm.
Regarding that, Lordship, PW8 is the IO. In his evidence in 6th line,
Just a minute.
regarding when he was examined, that part, Lordship,
9, huh?
PW8.
8, okay.
6th line, on 24/12/2003, OC so-and-so directed me to take necessary steps into the matter. Accordingly, I started investigation. I visited the place of occurrence. Injured Anjan Chanda came out of the house of Bhajan Saha, and I sent the injured person so-and-so to the hospital for treatment from Udharban to injured Anjan Chanda was sent to
Okay,
Sesame.
there is some explanation.
But that is on 24/12. It's not on 23. But he signed the exhibit on 20. Perhaps
No, read that first line. On 24/12, I was posted as so-and-so at around 1 a.m. Injured Babla Chanda appeared and verbally informed that on 23/12 at 8 p.m., his brother-in-law was assaulted by so-and-so, caused injuries on his body, and thereafter leaving the so-and-so on the basis of so-and-so, I sent the injured to hospital. What is the cross-examination? Okay, let us see the evidence of both Anjan and Babla.
Not
Anjan is PW1.
one.
I read it.
No, just give me 2 minutes. PW 9 was the. Okay. Come, that answer is there. Last line. Second page, first line. Sorry, second page, second line. My brother-in-law. Have you got it? So and so, I missed this yesterday. And so and so, so and so. On being chased by so and so, he was also chased by so and so. I then took shelter in the house of so and so. My brother-in-law Babla Chanda in meantime informed the police. Police came to the house of Bhajan Shahu, recovered me from the house. Police took me to Udharban PHC and from there I shifted to Silchar Medical College and Hospital. PW9 is a doctor in the Silchar Medical College.
Yes.
So he was given some preliminary attention at Udharban PHC.
But
So
that, I was saying that all
forget it.
24/12.
That.
If the person's two fingers have cut, the bar.
That is why he was given the treatment at Udharban PHC.
Udharban PH also by the 24/12 only.
No.
I was evidence is there, Lordship. I was
Then show me.
Yes, Lordship. That I have already shown. PW8. PW8 had stated that. 6th line. On 24/12/2003, OC so-and-so directed me to take necessary steps. Accordingly, I started investigation. I visited the place of occurrence. Injured Anjan Chanda came out of the house of Bhajan Sahu and I sent the injured person so-and-so to the hospital for treatment from Udharban PHC. So that is only on 24. He should have been died by bleeding till then.
There is something here because verbal assurance was at 8 p.m.
8 p.m.
night. And there would be some material that he was sent to Udharban. There has to be a GD entry, something.
Yes. Verify the entire. PW1s, if we go by the PW1, my lord.
And it is clear.
It is clear. And there has to be some treatment because otherwise he cannot survive.
He will not survive.
It's not survival. That cannot be any material contradiction regarding that. Whether there is any cross regarding that in the IOS, my lord.
That person, Bhajan Saha, was not examined. That is also another ground.
Oh. The doctor's evidence that we have read as PW 9. Okay. It says one patient 4:45 p.m. Just check up this. Here it is 4:50 a.m. not p.m. 4:45 a.m. he checked Babla. It is a.m. not p.m. It's wrongly typed here, p.m.
It is.
The report, medical legal, that report is here. So if it is 4:50 a.m., fine. That takes care. Go through it once. This. MR.
Emma,
So they were taken prior to that. They were that immediately at night they were taken to the Udarband, and from Udarband they were taken there. You just find that out for me.
medical report of my lord, whether it is for
Udarband is there.
Udarband, then it will be then Udarband.
Um,
One-
um, um, um. Exhibit 5 is the injury report. Exhibit 5.
The report is of my lord, 3 persons in exhibit 5, my lord.
But that is the medical legal. That is the from the extract from the
Yeah,
register.
register. Some discrepancy entered there. Regarding
So-
the time
If that be so, he received treatment.
loss.
He received treatment in the night itself.
Right.
And if that be so, then so that is gone. So doctor's thing gone. Vital we will take care. Then what about the contradiction of the place of occurrence you have said? What is the material?
There 1 million Bauri was examined as PW7, and he told that while he accompanied Anjan Chanda towards Sariali of the garden, he saw Babul Rikyasan, Ramchandra Bauri, and Babul Chanda and Ganesh Kari by the side of the fire. But it is the evidence of Babul Rikyasan that Anjan Chanda was sitting by the fire with Milan Bauri and others. So one said he was not there, but he saw others. But one other said that he saw the. But so except Milan Bauri, those persons were not examined. Even this
Okay, fine.
Taha was also not examined, and the driver, who is according to PW1, who had even fled away, he was also not examined, who was very much at the place of occurrence.
And PW7's injury, the record, the last page, his report in the, what do you call that, Udarban PHC, he was sent, said to be a simple injury.
Of the my lord, injured, my this of
No, this is PW7.
PW7.
PW7, Bilan Bauri.
Also sustained injury.
Injury.
While my lord trying to protect him.
So, Mr. Sharma, that doubt that is sought to be created for the defense, not there. And you had also taken a plea of alibi. But the evidences that I could go through, during cross, you never laid a foundation for that. And even in your 313, it's not there, I suppose.
313 is only total denial.
Denial.
That is what he's a layman, that must.
That is, he was supported by an advocate.
Lordship, but it's a 2003 meter 2013 judgment was passed. Still at present,
Isn't the police, if we go against him, police will find him out. Don't worry.
he was arrested on 20. He was arrested on 26/12/2003, and on 8404 he was granted bail because of completion of the statutory period. Court bail was granted. He was there for 3.5 months, around almost.
26/2003.
26/12/2003
26/12/2003.
to 8404 bail granted. 8404 court bail. 404.
How much days where was he there?
He almost 3.5. And a half. And at present, He is 67 as per the affidavit.
67? That is no age.
Like, I don't know whether he is still alive or not. That much instruction also I don't have. But as per affidavit,
That is no age. Yes, Mr. Goswami.
Lordship, first of all, my learned friend is saying regarding the motive part, my lord. What I have seen, my lord, there is evidence of PW7, my lord. From the PW7, your lordship will that he has uttered while, my lord, because he is a contractor, my lord. He has uttered like, my lord, no one is allowed to work here if you are outside. my lord.
There
That
is a
is-
statement.
Yes, so that is.
That is
but-
of PW7.
Yes, that is a motive, my lord.
That is with regard to the accused.
Accused,
Accused accosted the
Yes.
victim saying
Victim.
this thing that you
Yeah.
don't come.
you don't come.
Outside
is-
villages are not permitted.
Yes, that is one of the motive. And regarding,
I think there is a tick mark somewhere given by me.
yes, I've seen that.
I think I read that.
Yes,
There is
my-
a maybe a tick mark is given. Yes, okay.
That is one part, my lord.
Hmm.
And regarding eyewitnesses, not only one, my lord, there are 3 eyewitnesses, my lord. They are very much.
Eyewitnesses, PW,
PW, one is also, my lord, he's a injured.
Injured
witness,
person.
Injured plus eyewitness, my lord. He's,
PW2,
yes, and
And?
eyewitness and other things, my lord. His witness has to be, my lord, regarded as a defined pedestal, my lord, regarding the victim witnesses, my lord. So PW2 is also eyewitness, and PW3, though not eyewitness, he was reported, my lord. PW4 also is an eyewitness, my lord.
Hmm.
And then 7, PW7 is vital, my lord, who have supported the case of PW2, my lord, that he had gone there. to-
PW4 is eyewitness. here.
PW4 is also eyewitness.
And PW7.
7, my lord. And PW5 also, my lord, he has noticed injuries in the back also, my lord, of the injury.
PW7.
PW5 also stated that, my lord.
The injuries match
Yes,
with the
it
MR.
is. And which relating to the medical report, my lord, there is 5 injuries. One is the fracture part also, the cartoon, the right shoulder, cartoon in the left shoulder, then imputation of fingers. Everything matches with the statement of the victim, my lord. When there is my specific eyewitnesses, my lord, even one eyewitness, if it is inspires confidence, my lord, can be a conviction can be made. Doctors, therefore, my doctor's witness is very much, my lord, important at this regard, my lord. That report is, my lord, exhibited and is specifically stated regarding the medical report of exhibit, my lord, Milan Bori and others. Milan Bori also might sustain injury. That is,
আমার এই ডিসপোজ গিটা যিকেইটা আছে দি দিবা ইয়াতে মই সেকেন্ড অফ ইয়াতে দি দিম জাজমেন্ট ইয়াতে দি দিম বাট বুলেট was it 20 item দি দিলে we'll pass the order in the second half.
no, see. And here, my lord, I pray for sustaining the
Maintenance.
conviction.
Prayer
my lord.
accepted.
My lord.
Sorry. The contradictions are very minor.
Very minor. And that part your lord,
Second half,
yes,
we'll see and we'll pass the order.
AM PM lordship has already mentioned.
That is a mistake.
Yes, that is a mistake in the evidence part, my lord.
MR, it's 4:45
Yes, ma'am.
AM. So evidence,
That also I have read from the evidence, my lord, that skip
PW 89.
night.
So that gave me a,
Yes.
that created a doubt. So now it's clear.
Yes.
Thank you. You are as an amicus here
No, my lord, is not a mech.
no, I am the counsel.
or counsel. Okay. See, that day, if you had done the matter, maybe I was in your favor. Made me read it once again. I'm now against you.
I prepare for some.
Now I am against you. There are material.
Lordship.
That day I missed out on something. You made me read it once more.
Yes,
So now I am against you.
Lordship. First of all, Your Lordship.
Forget all these things. You disputed your signature.
Yes,
What steps did you take thereafter? Did you file a petition?
Lordship.
And presumption,
Yes.
you are the officer in charge. Any message sent comes to you. Sending of message is proved.
Demonstrate that, Lordship, one by one, Your Lordship. Now, first of all, Your Lordship, PW1. Under what circumstances this proceeding has been drawn up, Your Lordship?
We are not concerned with that.
Lordship,
We are concerned whether you received a notice or not. Because you are violating a judicial order. That day I was with you because I somehow draw an impression that that notice may not have reached you. But here the notice had reached you. And it seems now that you were trying to protect that accused.
Getting something protecting himself, Your Lordship. Well, Your Lordship, burden of proof, Your Lordship. Burden of proof is always there with that prosecution.
Section 174.
Okay, Lordship. 170.
It's a minor penalty given, but it's a major offense.
Here, Lord.
So you here the second part will apply. Intentionally omits to attend that place or time or departs from the place or time where he is bound to attend before the time at which he is lawful for him to depart, shall be punished with imprisonment for a term which may extend to 1 month, or with fine, or which may extend to 500 rupees, or with both. So you will come within the second part. So you intentionally omitted to attend. Show me.
Yes, Lordship. Your Lordship, PW1, Your Lordship. Under what circumstances this proceeding has been drawn up, the Lordship, complaint proceeding, Your Lordship?
It starts on 8/12/2009.
Lordship.
When you were required to be present in person on 7/1/2010.
Lordship, in GR case number, Your Lordship, 2266/2008, Your Lordship.
Public record.
Your Lordship, in the course part, Your Lordship.
Cross of PW1.
Yes, Lordship. He was then JMC first class, Lordship. Court issued the notice to that Lordship accused for that Lordship. Course part, Your Lordship. No, we maintain sorry. Course part, Lordship. The accused Muslim, sorry. The Muslim Matiu Rahman of GR case number 2268 was not shown as the absconder in the search, Lordship. And when the court initially directed that OC Mikirbheta PS, court was not aware as to who person was not holding the post.
Actually, he will not know.
Lordship.
How does it make a difference?
Mikirbheta PS number so-and-so, Lordship, and was directed to SP Morigaon, later on DIG, DIG prosecution, and DIG admin was also asked to cause the appearance of the OC. The reserve officer Morigaon was also asked to inform the OC
the DIG admin and DIG prosecution through that received that process of the court did not inform the court that communicate the order of the OC Mikiveta PS. There is no such document on the part of that SP Morigao informing this court that the SP has communicated that order to that OC concern. If the court process really relates to that outpost of a concerned PS, then the OC concern of that PS may send that process to that IC of that outpost for service execution, Your Lordship. There is no document in the record of DSP Morigao regarding his direct intimation to that accused OC Rahman, directing him to appear before my court on the date fixed. The ASI Sukumar Boro did not furnish any such document regarding his intimation to the OC Rahman, directing him to informing to appear before my court on the next date.
So
Lordship,
this is his evidence.
Lordship. So
This
there
is his
no
evidence wherein
document.
he had, wherein he refers to the proceedings of 13/7/2010 in all probability.
Lordship.
This is that when after the DSP had asked the RO to serve the notice, the next date was 13/7/2010, he was to appear. On that day, he did not appear, but you did not appear, the RO appeared.
RO appeared.
RO said, I have sent him a notice, he did not come.
Lordship, here in the one point, Your Lordship, Lordship, when a notice delivered to an addressee, Your Lordship, and then who served it?
What is that notice? It's a WT message.
Lordship, WT message, WT message.
WT message goes to the Hana.
Hana, yes.
And that means you are not a good officer. They don't give you patta. Being the OC, you don't get patta.
Lordship,
That is very difficult to. That point I missed out last time. And you made me read. So that point has come back now. Now you satisfy. Now come to the RO, Sukramboro. DSP, it's of no use because she said, I did not do it personally. I asked the RO to do it. Now you see PW2.
PW2. So in the PW2, Your Lordship, in a CFERT, he deposed that he delivered it. But Your Lordship, in the course part, Your Lordship, in the course part, Lordship, probably second, third line, Your Lordship. In Exhibit 4, I cannot recognize the signature of the person who received it. From the Exhibit 3 and 4, I cannot say as to whom I have endorsed the copy of the WT message to that served upon ASI Rahman, Your Lordship. Who served that WT message, Lordship? He himself did not recognize Lordship's signature. Acknowledgement, Lordship. Exhibit
You
4,
are reading Sukram Bora.
Your Lordship.
Across. We maintain a register.
Lordship.
So read from there.
Lordship. We maintain a register of WT message received in that reserve officer.
So this is incoming.
Lordship. We also maintain that display.
So this is outgoing.
Lordship. And that through that APR. And I have not brought this register today before the court. And this line, Your Lordship. In Exhibit 4, I cannot recognize the signature of the person to who received it, Lordship. And from the Exhibit 3 and 4.
Where is Exhibit 4?
Exhibit 4, probably, Lordship. WT message, Lordship. It's the Exhibit 4.
Evening, huh? You have exhibit 4 with you?
Yes, Lordship.
So this was received
Acknowledged,
by
Lordship.
the WT message
Yes, Lordship.
number 396. That is exhibit 3.
Lordship.
Protini. Exhibit 3 was received by somebody in Mihirbata police station.
Lordship.
Huh?
Or, Your Lordship.
Exhibit 4 is the acknowledgement,
Acknowledgement.
but exhibit 3 is the WT message.
Lordship.
Huh?
Yes.
So WT message was sent to that police station. That much is accepted.
I am not accepting Lordship. If it is Lordship, I am categorically Lordship denying that I have not received that message, Your Lordship.
Now, why is the acknowledgement received? They have proved, forget your acknowledgement part. Let us see whether the WT message was sent or not. From the evidence, I have not brought this register before the court. In exhibit, I cannot recognize.
There is
From
no
that
such-
whom I have endorsed the copy of the to be served upon SI.
They may depose that WT message has been sent to on their dispatch, but they didn't execute any register from that office, Lordship, concerned office, that WT message has been received or dispatched, Your Lordship.
Once a DSP orders, police setup, it's very difficult. Who is Sarmishta Burwa?
Was Lordship and the DSP, Lordship. Both.
This is a criminal revision, no? Your statement was also recorded.
DW1, Your Lordship.
Read the cross. 2009 চনত last part of
Last part of মই
Mihirbata OS হিচাপে উদ্যান কৰিছো আৰু 10 চনৰ থাৰ্ড পাৰ্টলৈ পৰা ট্ৰান্সফাৰ হম। Third part would be sometime in October. সত্য নহয় যে ডিএছপি মৰিগাঁও ৰিজাৰ্ভ অফিচাৰ সুক্ৰাম বৰাই জৰিয়তে মুঠ নগাঁও জিএমচি কোৰ্টৰ concurrent findings. Two courts.
Of the matter, they have my lord, in fact, my lord, the cross part is not been examined by the not been mentioned in the judgment by the court below, my lord. I'm not on that man now, my lord.
But you had taken this plea before the appellate court.
Only my lord 114Z and 103 evidence set. And when burden shift to me, my lord? Is my lord in Indian law, my lord, prosecution has to prove the first. They have to prove, my lord, this burden now, my lord, this burden was shifted to me, then I am not denying. I have to prove that this is my signature. How can I, my lord? Until and unless, my lord, prosecution established that, my lord. Your lordship kindly see the section they have mentioned 114Z and 103. These are not applicable in my case, my lord. Suppose I have said that, yes, on that day, my lord, I was not there, I was in somewhere place, then that is my duty. That is my special knowledge. Because if I said I take the plea of alibi, that yes, on that day I was not, I was absent, then I can, my lord, that is my duty.
What is this exhibit 3?
3.
Okay. Yes, Mr. Borwa. Have this.
Already heard me, my lord, on the last occasion, my
No,
lord.
no, no,
I'll just show one line, my lord.
no, no, no.
May kindly
Take
peruse-
this, take this, take this, take this, take this. Oh, we develop daily. Now, exhibit 3, you see, that is that was where I was having some confusion. Exhibit 3 is a WT message from the court to RO and the petitioner, right? Appear on 13/7/2010, right? Now, how did you forward this? Because this went to the DSP. DSP forwarded it to the IO. Now, how did IO forward it to the Mikirbita police station? Whether a WT message was sent, whether it was sent through peon book, or whether it was sent by a messenger, how did it send? Where is the evidence to that effect? That much only show me.
Yes, my lord, it is mentioned that, my lord, please inform OC Mikirvata police about the date of appearance. They'll also appear as directed, my lord.
Now, how
my
did
lord,
this?
There is the endorsement, my lord, received.
That is in Exhibit 4. Next page. Now, how was this sent to Mikirbata police station?
There are some, my lord.
No, where is from the evidence you show me?
There is no direct evidence to this. Then, my lord, I just saw one line, my lord. Lordship satisfied, my lord. I have nothing to submit after that.
You really wanted to put.
Just peruse the 313, my lord. Question number 3, my lord. Last question, my lord. This is answer, my lord.
Fine, no problem. 13/7/2010 is an order.
Five is the order, my lord. 13/7/2010.
No. You check up. That is earlier to that. Exhibit 5 is for appearance on 13/7/2010. Exhibit 3 and 4 is for appearance on 13/7/2010. So when he went there on 13/7/2010, a further order was given in a seal cover. And then the proceedings started.
Was aware about the 13/7/2010?
No, 13/7, there is no violation. 13/7, it's here. If you can come to the judgment, you will find it. In his evidence, the accused stated that he received the 13/7/20 on so and so, after which he appeared in the court. So 13/7, a date was fixed. But the proceedings started because he did not appear on 13/7. So the other part, it's not, because the other part question you will find next. Deposed that Exhibit 3 issued by PW was put up before her and so and so. So and so, PW appeared before the PW1 on 13/7, carried the copy of the order to her through WT. The copy was served upon you. W46, Sohi Mur Nohoy, Kunu, Porto, WT message, Muk, same Kora Nai. So 13/7, that appearance, it is correct. He appeared the next day. But the violation is of 13/7/2010 and prior. Prior, there is no material. It's 13/7 that is material. That order is of 26. Here's what is the order? 26.
46 or
22/6/2010. Requiring appearance of 13/7/2010. Yes, Mr. That is the order. 22/6/2010. Annexure 3 and 4 is to that effect only.
That order.
My lord, in his cross-examination, my lord, of W1, my lord, the person, my lord. He said, my lord, 2010 or sonor third part of pine tarpor transfer ho.
Third part is December.
He was
October.
Yes, he was present, my lord, till September, my lord, assuming, my lord. And my lord, he denied, my lord, receipt of Exhibit 4. Exhibit 4 was received on 24/6/2010 in Mikirvata PS, my lord. That was present at that.
What? Exhibit 4.
Cross-examination, my lord.
Oito nohoy je exhibit 4 more.
Denied.
Sohi ase. Receipts or sohi more nohoy.
My lord.
Oito nohoy je court of review. Okay, we'll see at second up. Because how old is he now?
84 now.
Huh?
74, 76. No, he's totally bad in arm problem is there, my lord, he cannot stand up. No.
You're not anyway sending him to jail. Don't worry.
No, my lord, even your lordship kindly see here, my lord, all the court below, my lord, the order shift to me, that's why my lord conviction was maintained. But that is not the law, my lord. Simply they shift the burden to me. I am not being proved that. I have to have sent it to the forensics. But that is not, my lord. First, they have to prove it, my lord. Prosecution has to prove it, my lord. That yes, we have served it, this is his signature. It is in front of me, my lord, that is there. So how to serve a notice, my lord? There is a procedure, my lord.
Being an officer in charge of the
So
police
that's
station,
not
my lord.
presumption, my lord. This is
No,
not
this
a
is not
petition.
presumption, my lord. It cannot be, my lord.
Presumption, my lord.
A judicial order, my lord, the judicial order, my lord, when it is served in the police station, my lord, it cannot be
Mr.
denied, my lord. The
Monto.
office, OC was not informed.
We are trying to find that loophole to be covered by,
My
the
lord.
porthole is there. We are trying to cover it. There is a porthole in the whole thing. But besides this, that's why I told Mr. Gogoi that if you have not received that, you are not a good officer. Nobody is giving you patta there.
My lord.
That argument will not stand. I'm only trying to see whether the 3 and 4, as the lower courts have, the trial court and the appellate court has held.
I leave it to your lordship, kind of, because your lordship, I understand, my lord. Your lordship, everything, every page your lordship have read. I understand.
No,
So,
not
my
reading, not reading. I'm ready to give you probation, but I'm trying whether I should acquit you.
My lord.
Only that much. Yes, Mr. Borua.
My humble submission is this, my lord, that being the officer in charge, my lord, and he himself stated, my lord, that 2010 was 2010 sonor third part of that's transfer home, my lord. It means at the time relevant period, my lord, he was very much.
There is no dispute with that.
And he being the officer in charge, my lord, it cannot
But
be
only
denied.
thing is whether 3 and 4 had reached him.
That is, my lord, as per
And
the-
how you have sent it, that explanation is not here. Whether you had sent it by way of a
question
messenger,
is that,
whether
my
you
lord,
had sent
that
it.
has been exhibited, my lord, during the
I know
trial.
that. I know that. But how did 3 go to become 4?
That has been how it was forwarded, but there is nothing, my lord. Question is that, my lord, that has been exhibited, my lord. Yes, and that it is exhibited during the trial, my lord.
And he was comforted, he denied it. See, that signature is not his. Fine, that signature is not his. Maybe if we go for a FSL also, that
No,
signature
my
may
lord,
not be.
generally, my lord, when my lord WD message is sent, my lord,
That is
sir,
what I'm
sir,
saying.
never accept, my lord.
No. Whether it was a WT message, new WT message sent, or a copy of the Exhibit 3 was sent to the police station, somebody received it there. Who received it? He has not been examined.
Question is there, my lord, whether it was the information was there or not, my lord. That is the prime question, my lord. Third, the concerned, my lord, who was the officer in charge of that police station, my lord, whether the information he received or not, my lord. That has to be looked into, my lord.
That is what I'm
Sir,
trying to
these are
say.
mere formalities, my lord.
See, there is a statement of the PW 1022 that he had even telephonically informed him. Now, if that telephonical information is given, some call records would be there. CDR, what do you call that? This is of 2010, maybe it was a landline, but that details can
No,
be also
2010,
placed.
my lord, mobile was very much available.
Well, then if it is mobile, it was very easy, more easy.
Lordship,
Otherwise, we are not very happy with the manner in which the petitioner was going along.
and another aspect, my lord, Exhibit 1, my lord. This is the statement of CW1, my lord. Puram Boro, my lord. He said, my lord, I also informed the OC, SI, Rahman, and asked him to appear before the.
He informed him by way of telephonic message.
Yes. And no, my lord. I also informed the OC, SI Rahman, and asked him to appear before the court. I also telephoned the OC, my lord. My lord, he has, my lord, informed through telephone also and verbally also, my lord.
Verbally, he does not say.
I also informed the OC.
I also informed what was the nature of that inform, whether it was by sending that copy of that Exhibit 3.
The judicial statement, my lord, was examined as CW1.
But Mr. E.J. Mohanto, along with Mr. T. Gogoi, learned counsel for the petitioner, also heard Mr. R.J. Borua, learned counsel for the learned additional public prosecutor appearing for the state. So, the petitioner, by way of instituting the present criminal revision petition, has presented a challenge to the judgment and order dated 21/6/2013, passed in criminal appeal number 44 bracketed N oblique, take your seats, 2011 by the learned additional session judge dismissing the appeal and thereby thereby upholding the conviction and sentencing under section 174 passed by the Additional Chief Judicial Magistrate, Nagaon, in GR case number 2718/2010, convicting the appellant herein, the petitioner herein under section 174 IPC and sentencing him to undergo 10-day civil imprisonment along with fine of ₹500 under section 174 IPC, in default of payment of fine to undergo 2 days simple imprisonment. Also, as projected in the present petition, the petitioner herein was at the relevant point of time the officer in charge of Mikir Beta PS police station under police station in the district of Morigaon. Also, in connection with GR case number 2266/2008, bracketed State of Assam versus Muslim Rahman, instituted under section 279/338/304A IPC, notices were issued for summons were issued against the said accused Mir Matiur Rahman to face trial. First, they said summons were required to be served upon the accused in the said case through the officer in charge Mikir Beta police station. The summons not being served and the said accused not having appeared in the case, the judicial magistrate first class Nagaon, on 8/12/2009, issued an order in GR case number 2266/2008, fixing 7/1/2010, and required the officer in charge, Mikir Beta police station, that is the petitioner herein, to appear before the court full stop. The said order was issued through the Superintendent Police Morigaon, full stop. It is projected that although the petitioner herein was instructed to appear before the court on the date fixed, however, he did not turn up. Full stop. Thereafter, on 22/6/2010, the petitioner herein was directed. The court directed the Deputy Superintendent of Police bracketed headquarters, Morigaon, to cause the appearance of the petitioner herein before the court on 13/7/2010. Full stop. It is seen that on 13/7/2010, the reserve officer ASI Sukram Bora appeared before the court and informed the court that he was directed by the Deputy Superintendent of Police bracketed headquarters Morigaon to inform the petitioner herein to appear before the court on 13/7/2010 in terms of the orders passed in the matter by the court. He also projected to have made a telephonic call to the petitioner herein, informing him about the order passed by the court. Also, the WT message issued in this connection to the Deputy Superintendent of Police Morrigaon, bracketed headquarter, Deputy Superintendent of Police, bracketed headquarter, Morrigaon, was also contended to have been forwarded to the Mikirbeta police station, and the petitioner was accordingly informed of the same. Full stop. The said WT message was exhibited as Exhibit 3, whereas the acknowledgement thereof of its receipt in the Mikirbeta police station was exhibited as Exhibit 4. Not like it to cut it yet. Full stop. The petitioner not having appeared, comma, on 13/7/2010, the court handed over an envelope to the reserve officer ASI Sukram Bora, wherein an order was enclosed with a direction to hand over the same to the Superintendent of Police, Morrigaon. It is projected that the said envelope was handed over to the Additional Superintendent of Police, Morrigaon, by the said reserve officer, who in turn forwarded the same to the DSP bracketed headquarter for a necessary action. It was also contended that the said order was, a copy of the said order was also handed over to the petitioner herein. So, thereafter, the proceedings in GR case number 2718/2010 under section 174 was initiated.
CR, Your Lordship.
Huh?
CR.
CR.
Your Lordship.
CR case number 2718/2010 was initiated, was instituted, and wide and on appearance of the petitioner in the matter, comma, was instituted, and the cognizance thereof was taken by the Learned Court, wide order dated 15/7/2010, and summons came to be issued to the petitioner herein to face trial. For subpara. On appearance of the petitioner and after compliance with the provisions of section 207 CRPC, the particulars of the offense under section 174 IPC being read over and explained to the petitioner herein, and he having pleaded not guilty and claimed to be a trial ensued in the matter. Also, on conclusion of the trial, which was conducted in the matter by the Additional Chief Judicial Magistrate, Nagaon, the Learned Trial Court, upon appreciating the evidences coming on record, and as well as after considering, after coming on record, proceeded wide judgment and order dated 29/9/2011 to convict the petitioner herein under section 174 IPC. On such conviction, the petitioner was sentenced to undergo 10-day simple imprisonment along with fine of ₹500. In default of payment of fine, the petitioner herein was held to be liable to undergo further 2-day simple imprisonment. The petitioner being aggrieved by his conviction by the trial court, assailed the same by way of instituting an appeal, being criminal appeal number 44 N/2011 before the court session judge Nagaon. Foso. The said matter was assigned to the court of the additional session judge Nagaon for disposal. Also, accordingly, the said appeal was taken up for consideration, and upon appreciating the evidences coming on record in the before the trial court, the appellate court wide judgment and order dated 21/6/2013 was pleased to dismiss the appeal, upholding the judgment and order dated 29/9/2011 passed by the trial court in the matter. Also, being aggrieved, the petitioner has instituted the present proceedings. Mr. T.J. Monto, learned counsel for the petition for learned senior counsel, along with Mr. along with Mr. T. Gogoi, learned counsel appearing for the petitioner. After taking this court through the witnesses adduced by the prosecution witness, evidence adduced by the prosecution witnesses, as well as the statements made by the petitioner under 313 during his examination by the learned trial court, has submitted that the learned trial court had committed gross irregularity in convicting the accused person. So it is submitted by the learned counsels that the said conviction was not based upon a conclusion reached that the charge framed against the petitioner herein under section 174 IPC was proved beyond a reasonable doubt. Also, by referring to the evidence adduced by PW2, that is ASI Sukram Bora, who was the reserve officer, it is submitted that although therein a deposition was made with regard to the communication made to the petitioner herein of the WT message issued in the matter by the court requiring the presence of the petitioner on 13/7/2010. It is submitted that the above, which was exhibited as Exhibit 3, it is submitted that the said WT message was issued to the Deputy Superintendent of Police, bracketed headquarter, Nongao. So, by referring to the Exhibit 4, it was submitted that the Deputy Superintendent of Police, on receipt of the same, had made an endorsement thereon, requiring the reserve officer, that is the PW2, to inform the petitioner herein of the next date fixed in the matter and require his presence before the court on the said date. By referring to Exhibit 4, which is projected to be an acknowledgement of the said WT message, that is Exhibit 3, it is submitted that although the same reflects that although the same contains a signature with the words apostrophe 24 with the date 24/6/2010 itu apostrophe tagibo and MBT.PS, the petitioner during the trial had denied the signature therein to be that made by him, to be of his. Also, it is submitted that the evidence adduced by PW2, it is not clear as to in what manner the Exhibit 3 WT message was forwarded to the Mikirpeta police station. Also, the learned counsel for the petitioner, submit that the petitioner was not in the know-how of the directions passed by the learned court requiring his presence on 13/7/2010 and accordingly and on any prior date inasmuch as he was not informed of the same by the either by the court and or by his superior authorities who had received information in this matter from the court. Accordingly, it is submitted by the learned counsel for the parties that the ingredients of section 174 IPC not having been found to be satisfied in the matter, the conviction of the petitioner by the learned trial court would mandate an interference. Also, the learned counsel for the parties have, by referring to the decision by the judgment and order passed by the judgment and order dated so and so passed by date to the passed by the learned trial court, has submitted that although in the appeal, the learned appellate court was apprised of the matter of the defense taken by the petitioner in the matter, as well as the shortcomings coming to the notice during the trial, which had the effect of rendering the conclusion drawn by the learned trial court of the charge framed against the petitioner herein under section 174 to have not been proved beyond reasonable doubt. The learned trial court ignored the said aspects of the matter and proceeded to draw conclusions to the effect that the petitioner, in spite of having knowledge of the date in the matter and that he was required to appear before the court on this date so fixed, which he had failed, proceeded to uphold the conviction and sentencing as made as passed by the learned trial court, while the judgment and order dated 29/9/2011. Also, having made the above submissions, the learned counsel for the petitioner has made an alternative submission to the effect that neither the learned trial court nor the appellate court had considered the provisions of section 360 CRPC or the provisions of the Probation of Offenders Act 1958. Also, it is submitted that the petitioner having served in the police force for around 34 years at the relevant point of time, and there being no allegation similar to the one leveled against him in the present proceedings, the petitioner was entitled to the provisions of was entitled to be extended with the benefit of probation in the matter, which was his right, and the same was not considered by the learned trial court nor by the learned appellate court in the matter. Also, the learned counsel for the petitioners have also submitted that the petitioner for the last around 15 years have been litigating in the matter, initially before the trial court, thereafter before the appellate court, and presently before this court in the present revision petition. And it was further submitted that the petitioner is presently aged around 74 years and is bedridden on account of various age-related ailments. Accordingly, it is submitted that this court would take a lenient view in the matter and not require the petitioner to undergo the imprisonment as awarded in the matter by the learned trial court, which was upheld by the appellate court. Also, per contra, Mr. R.J. Borua, learned counsel for the learned additional public prosecutor appearing for the state respondents, by referring to the evidence adduced in the matter by PW2, has submitted, that is the reserve officer, has submitted that the said evidence would bring to the forefront that the WT message at least was brought to the was served upon the was forwarded to the Mikirbeta police station, and the same was received therein. So he submits that even if the signature of the petitioner in the acknowledgement, that is Exhibit 4, is disputed, the fact that the said WT message had reached the Mikirbeta police station is clearly established from the evidence of PW2, and accordingly the petitioner being the officer in charge of the Mikirbeta police station, non-receipt of the said information as projected in the matter by the petitioner would not mandate an acceptance by this court. Also, Mr. Borua has further submitted that the evidences as brought on record, including the 313 statement adduced by the petitioner herein, including the statements made by the petitioner during his examination under section 313 CRPC, would go to indicate that the petitioner had knowledge of the orders passed by the learned trial court requiring his presence on various dates, including that on 13/7/2010, and it is seen that the petitioner had willfully refused to appear before the court, and accordingly, the ingredients of section 174 being satisfied in the matter, offense being made out, offense being established beyond reasonable doubt, the conviction of the petitioner by the learned trial court would not mandate any interference from this court. He further submits that the appellate court had, on consideration of after reappreciation of the evidences coming on record, had drawn its conclusion, which is also based on the evidences, which is also supported by the evidences coming on record during the trial, and accordingly he submits that the conclusions and the conclusions reached by the appellate court would also not mandate an interference. He submits that the court in the present revision petition is only required to examine as to whether there was any irregularity in the appreciation of evidences in the matter by the learned trial court and the appellate court, and this court in the present proceedings is not called upon to reappreciate the evidences coming on record in the trial. Accordingly, he submits that the present revision petition would mandate a dismissal, upholding the judgment and orders impugned in the present proceeding passed by the learned trial court as well as by the appellate court. Anything more to be added? Any idea? Disposed of. Only thing I'll think how to go about it.
Argument.
What?
Written argument, Lordship.
We will take care of that. Whether your para 9 should be done or para 1 to 8 should be done, that I'll think. But it will be either of. You're not going to jail. That much you can take it from me. Mr. Borua, they are not going to jail. But whether I should give him a clean acquittal or I should give him probation, that I'll think. And these are matters wherein the state should have been very upgoing in doing it at that point of time. After 18, 19 years, we don't expect a 74-year-old man to go to jail today. Get my point? I'm finding it, these are cases, if it had come in at that point of time, the conviction would have been upheld, should have been upheld. But now, maximum cases. Can't help it. Because we'll also have to see the changed circumstances. If it is too heinous, okay, fine, we'll do it. But in this matters, we had dismissed yesterday one case. Cases are pending here. See, that reflects on us, on me. Yes, true. The court, we are the prime person to be blamed. But you also have a responsibility. Because when this thing goes out, it goes out as the court, not as a judge, not as a prosecutor, not as a petitioner. It goes out as a court. And that, I don't find it very... It's good that this chief has given me this bench, I can learn something. But seeing the manner, not very... Anyway, can't help it. Yep. Yes. I think you have got your relief by being out for such a long time. Now go back to the jail. Or you satisfy me. 354.
354, my lord.
Incident proved. PW1, PW2.
But place of occurrence.
Place of occurrence is the cowshed, because that is also a dwelling place.
dwelling place.
That when I saw it first, I also had a doubt. But if you go through clearly, there is no cow there. She was sleeping there.
But
And the father's evidence is very clear. It's in the cowshed. He went to the cowshed.
but in the 164 statement, victim stated in the living room, dwelling house.
Small girl.
And-
How old is she?
Informant also.
How old is she at that point of time? 9 years.
9 years.
Ah.
Subsequently, he stated in the cowshed. And mother also stated in the dwelling house.
For the purpose of committing theft, committing an offense. And for that purpose, you have also highlighted that the accused had come back. First he came, mixed, went away, and thereafter, after some time towards the later part of night, he came back. And then he inquired whether the family members had the food or not. So you say that this is to commit that robbery. So that is the line that was there. Now you come to 328. I may be wrong also. Can you read 328?
By any person.
Stupefying. So this is one. With
Or with intent to.
with cause hurt or to such person. To commit or to facilitate the commission of an offense. So there are two parts here. Whether I don't know, with intent to cause hurt to such a person, or with intent to commit or facilitate the commission of offense. So the mixing of the drugs or whatever it is, the substance, has to be to cause harm. No, where is that? Because why I'm saying so, if you come to the impugned judgment, come to the impugned judgment here. Where is that? Session judge. To come here. Para 21. Just read para 21. Oh. Record. Para 21. Internal page 16. So 457, 380 is not also proved against the petition appellant here. Hmm. But, no, he's not convicted under 457, 380. He's not convicted. Then that means that part, second part for bringing into effect 328, not established. Mr. Bishwas, a slight one suggestion from you. 328, if we can have that book. Ekon Dioksu. IPC. What is your understanding about 328 here? That only by usage of drug, the crime is proved, or the second part is also to be taken into consideration. 328, 128 page. IPC.
Administrators of the drug or other
That's it. So the one part is whoever administers or causes to be taken. That is one part. Then it starts with the intent to cause harm to such person. So this drugs has to be with the intent to cause hurt. So evidence should be there. Merely usage of the drugs is not an offense, but with the intent to cause hurt. Or with the intent to commit or to facilitate the commission of an offense, or knowing it likely that he will cause hurt, shall be punished with so and so, and shall be also. So administration of drugs must be with the intent to cause harm or to commit an offense. It can be anything. But both should go together to get 328 into operation. Am I right in understanding that?
328. Or is this to cause hurt to such person?
In this case, it is this part that is there. That part not proof. So where is that 328? Hmm. 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 There is ample evidence on record. So where is this material? Where is this material to cause harm? He had done it. Your projection is he had done it to commit the theft. But where is the harm thing? Go to the charge sheet, go to the charge sheet, go to the charge sheet.
Ahmed Ali.
That's it. So it is to commit that offense that this was done. So that part is not proved. Whether he can be convicted under 328. That there is no material that this persons had committed that offense, because now they are all.
My lord.
Hmm.
That's my lord. The next day evening, my lord, day. Earlier day, night, my.
Why don't you, means, this is something which is troubling me, 328. If we can show some judgments that mere administration without that second part will also bring in, then fine, that's the end of the matter. Okay, we'll have it tomorrow? Monday, okay. Mr. Mandal, moment I get that this is the doubt I'm having, if we can clarify it, then that is the end of the matter. Rest is taken care. Heard Mr. M.E. Mandal, Learned Counsel for the petitioner, also heard Mr. R.J. Borwa, Learned Counsel, Learned Additional Public Prosecutor. Parties were heard at length. Mr. Borwa, Learned Additional Public Prosecutor, submits that he be granted time till Monday, Monday, Tarik to Diriba, to place on record judgments in support of his submissions. No, vice. Registry to list this matter on 22/9/2025 as a top of the list matter in the top of the list column as a parted matter. Yes, madam, what have you found?
Lordship, PW3 Lordship.
PW3.
3 Lordship.
Hmm.
PW8, PW13 and
Just a moment. This is item number? Okay, fine. It was done in March. Man died in February. Yes, madam. PW?
3 Lordship. He has
Three.
state
Then?
PW8, PW13 Lordship.
Okay. What does PW3 say?
PW3 states that
What was the name of PW3?
Ajay Chakravarti.
Yes. Five. PW4. PW3, yes. Ajay Chakraborty.
Stated that on 3/2/2009, the accused had come to him and asked him to prepare one general power of attorney. Accused was accompanied by another person.
Who's the advocate?
Yes, Lordship.
Advocate.
Who identified himself as Faizolal Kemprai. Accordingly, Chakravarti prepared the general power of attorney in favor of the accused and put his signature as witness. Has put his signature as witness. Then both of them should have been there.
What is this cross here? He put his signature as his witness. Okay, it's there. It's exhibit. Then what is this cross? Nothing. Power of attorney at the time of execution in my presence. So this much only. Then next,
Both
PW8.
should have been there.
Huh?
Both of them should have been there.
Huh.
Then Lordship, PW8 Lordships, Ranjan Thausen. Stated that he verified the records of birth certificate and death certificate of Langting PHC and confirmed the death certificate of late Faizolal Kemprai was issued from Langting PSC. But that document is a very crucial document, Lordship, and that was not exhibited, Lordship.
Oh, this is before the district commissioner, DC. But there is evidence. He has, in all these documents, he has only written seen. Will not go into that nitty-gritties. But it says that the person, Fagi Lal Kemprai, had died on 22/2/2009, whereas the power of attorney was executed on 3/3/2009. So admittedly after. Then PW 13.
13, Lordship, Police Inspector. Kiran Das. He stated that he had not ascertained about the person concerned who actually put his signature as Faizolal Kemprai in the General Power of Attorney document, which should have been sent. The main signature should have been sent for forensic, Lordship, and that is missing in this case.
See, madam, one thing, the date of power of attorney cannot be changed. That is fixed. The date of death is fixed. So admittedly, the person projected is not there. What do you have to say on that?
Lordship, PW8 was not summoned, Lordship, and the main document, it was not exhibited, which makes the death certificate as a fake document, Lordship.
Okay, what is your cross with regard to that? Nothing. That person who had come down, have you crossed him? Is there a cross PW8? So you admitted the exhibition of that document, and the document is being exhibited by a officer from whose establishment that is legally required to be issued. So Births and Registers, Death Register, Registration Act. Your cross was declined. So you had not questioned him with regard to the validity of that. Not questioned him. Anything more, ma'am?
In Lordship, PW13, Lordship, we should have examined the signature of that of the deceased, Lordship.
This is,
From that, Lordship,
madam, if we hold that the death certificate 7/7/2009 is correct, then the spirit of the deceased would be here. The deceased cannot be here. So it's a false document, apparently, and he had used that to take the money out.
And PW10 has admitted that she got the money in presence of DW1.
You are referring to 13, PW 13. If we can come to the cross. Down below, last 2-3 paragraph. The seized power of attorney, it starts with. Have you got it? Towards the end. Just 1, 2, 3, 4th paragraph from bottom. Seized power of attorney was, you have got the evidence? No, you don't. It's written here. Seized power of attorney was executed by Kemprai, the accused so-and-so was the attorney. I had ascertained from the accused Ravindra Thousand about his signature, which was confirmed by Ravindra Thousand. But as regards the signature of the executant, that is the deceased person, he could not give any satisfactory reply. He must have be having some extra spiritual power to get. Anything more, madam?
DW10 admitted lordship, she got the money back in the presence of DW1 and DW2 lordship.
Where?
Page
No. DW. Which PW is saying that?
DW1 stated that.
DW1. Jambu Kamprai. Jambu Kamprai.
Stated that after the death of
But this has been dealt with by the learned trial court by saying that there is no material, there is no acknowledgement, there is no receipt given, nothing was given. And that, because there in the cross he says, I did not obtain any receipt from so and so after making. So this statement is neither here nor there. And that is not the issue also. The issue is whether that forged power of attorney was used to get the money from the works department. That was used, that is established.
basically his signature should have been question law.
Signature, how can you and see?
And nowhere in this, the wife nowhere mentioned that it is not the signature of her husband, Lord.
How can you? Because he is not there on that day. The execution is on a particular day. If he was alive on that day, it would have been a different question altogether. He's not alive.
Signature could have been sent for
From there. From there.
signature for his signature, Lordship, in the
How can you? Because this is executed on 3/3/2009. It cannot have a legal existence before 3/3/2009. Can it? Cannot have.
apart from that, Lordship, death certificate was also not exhibited, Lordship.
Fine. But that death is also not questioned by you. The person who has come on record, the register of that births and death, he has also not, you have also not questioned him on this count. And you permitted that to go on record. Permitted that a death certificate of late Fazilao Kemprai was issued from Langpring PHC wide registration number 16 of 09 dated 7709. This is also not disputed. Yes, Mr. Burwa. Hmm. 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 Okay.
My lord, informant husband.
Okay. And his 313 reply is also very interesting. He says that he did it to help the widow. Why? After the death is already established there. There is a interim order here. Yes, item number ma'am. Was he was not released. Nine. Okay. Dismissed. Sorry, thank you. Dismissed.
Please, Your Lordship.
Taking vision in Giba. In listen. We'll just finish. There are two more old matters. We'll just go through that and then come back.
Lordship.
What caterers have?
5 and 6. 5 and 6.
Mr. Bhattakur, what are you waiting for?
Hearing, Your Lordship.
Mr. Sikdar, you're also waiting for this. You're waiting for that. Okay. 25.
Letters, Your Lordship. One.
Petition, Your Lordship, challenging the disciplinary.
What is the, oh, Senilanda. Wouldn't be possible.
The date, Your Lordship.
Mr. Kumar is there. Have you informed him?
No, he is.
You are for the, Mr. Monto, you are there.
For the college.
Next second, sir. 25, 26.
Twenty-five is the criminal petition, Your Lordship, challenging the FIR, Your Lordship. FIR is the outcome of the disciplinary proceeding, Your Lordship. Based on the inquiry report of the. Therefore, to take both the matters.
So there was a, I'm sorry, I did not go through this yesterday. Being so engrossed in the whole matters,
I cannot.
this much I did not reach yesterday. Okay. So where is that inquiry report?
That Your Lordship will get in the writ petition. Lordship, the page 176.
Where is that finding with regard to the quantification with regard to the amount defalcated?
Lordship, at the end of 258, Your Lordship. Last line. $7,31,000.
So if there is a quantification, prima facie there is some material on basing on some material they have done it. So how can it mandate a quashing?
Lordship, so far as that, Your Lordship will kindly see, Your Lordship, therefore, Your Lordship, I will pray before this honorable court to take up the writ petition first, Your Lordship. And the writ petition, Your Lordship, the whole inquiry report, Your Lordship.
See, that writ petition is with regard to the inquiry.
Lordship.
That will take care of itself, don't worry. But this is a different proceeding. Only thing that can be drawn is that whether there was any basis.
Lordship.
They did not have a,
Now,
they
if
didn't,
Your Lordship-
they ought not to have even waited for this inquiry report to come. Before that they could have.
They could have.
Now they have an inquiry.
They did not, Your Lordship.
They did not. They did not.
Secondly, Your Lordship will kindly see that Your Lordship, so far as if this inquiry report goes, what will happen? That quantification itself will go, Your Lordship. That's the problem.
This will be an independent thing. This will be an independent thing. They'll have to establish this
Because
independent.
if Your Lordship kindly go through the FIR, Your Lordship find there, Your Lordship. Their entire case is based on this, Your Lordship.
Mr. Monto, why you bring all these things inside this FIR? Heard Mr. S. Bothakur, Learned Counsel for the petitioner. Also heard Mr. P. Monto, criminal petition today. Also heard Mr. P. Monto, Learned Counsel for the petitioner, and Mr. Das, Learned Standing Counsel, Higher Education Department. As agreed to by the
He is
Learned.
only in writ petition.
Oh, you're in the writ petition. Okay. Criminal petition. Nalage. As agreed to by the Learned Counsel for the parties, a registry to list this matter immediately after the ensuing puja vacations. Also, but whenever it's convenient, to tell me. On 20, Aji Birospati one, na? 23, 10, 2025. What's up? WPC likha, belek list this writ petition along with criminal petition number 1024/2014 on 23/10/2025.
There is a judicial order, you know.
Mr. Onto, if your wording in your FIR was not as it is today, I would have dismissed Mr. Bhattakur's petition today itself. You have brought the departmental proceeding, drawn the things, you look into your petition. No, you look into the FIR. If that line was not there, if it was only a thing of misappropriation, I would have dismissed this writ petition today. Sometimes too much elaborating is also a problem. So you get this writ petition dismissed, Mr. Bhattakur's petition will take care of itself. Yesterday, luckily or unlucky, unfortunately for me, I did not read it. I did not, because of going by this, it became too late. So I forgot.
Had your lordship gone through the writ petition, your lordship would have, your lordship, immediately your lordship allowed my petition. Your lordship.
Very doubtful.
Completely vitiated, your lordship. Completely vitiated. I will show your lordship.
Mr. Bhattakur, even if the writ petition is dismissed on
Then also, your lordship, that can be, your lordship.
on technical grounds,
Lordship.
the criminal proceeding cannot be stopped. There is a
both your lordship, criminal
next time it
proceeding-
comes before me, I'll come prepared. Don't worry.
Deeply obliged, your lordship.
Yeah. Abdul Qasim. Have you got that? No. Then what is 41? Yes, Mr. Bora. Having this very blank look, what happened? 20? Would be difficult today. Would be difficult. I've disposed of a lot of matters. Those have to be after vacation. We'll pass the orders, don't worry. When? Oh, you are also here. Okay. Joint prayer. Lekha. 28, 29. Correspondent. Where is Mr. Barbuya? Okay, let Mr. Barbuya come. Others, he might have many objections. So we will deal. Okay, after vacations, we'll deal. If you have any date, give it to her. Any date. Okay. Yes, Mr. Goswami. Hey, what is the purport of section 41? Mr. Bora, just, it's a right-hand thing, left-hand thing for you. Regulation, just have 41. What is the purport of this? That is 40. Attached to the breach of rule, any under that section, any punishment. So 41 is not the punishing provision. It only provides if there is a violation of the rule. Which is that rule? How can you then make 41 an offense? I have found 2-3 cases now where 41 punishment is given, but 41 it refers to some rule. Offense will be there, not here.
Some rules are there, madam.
So let me check.
I
Some
told
rules are there. One
I told
is
Mr.
one from 2002 and one rule is from 2022.
And this is 2000. The rule Mr. Bhattakur has given me is something else.
Rules to the
This is Assam, huh? There are two rules here. Where is that other rule? Okay. Okay. This cannot be from non-forest. That will not be 41. That cannot be a grievance under 40. So how are people drawing up offense under 41? Because that day also there was a matter. When did I fix it? Monday. We'll have this on Monday, Mr. Das. There's another matter. If you get something, just share it with Mr. Bhotthakur. You talk to Mr. Bora also, Mr. Bhotthakur. Mr. Bhotthakur, talk to Mr. Bora also. Tuesday. Okay, done. Tuesday. As agreed to by the Lana Council for the parties, raise the matter again on Tuesday. You can take this back. Mr. Das, as an officer of the court, if you can get some light here. Because how can a provision which says a violation of a rule will have it? Without that rule being there, how can there be a violation?
But the thing is that during trial, it is their burden to exhibit those rules.
That we understand, because we are getting a few matters like this. If there is something, we will not go into that. Okay. 40. With regard to forest. That's what I'm saying. It is from the forest. These rules that have been forwarded, page 87 or this is from non-forest land. So it cannot be forest produce. I got it. But when you are within the state applying this 41, there has to be a rule which is violated. They say rule 40, section 41 violation. Section 41, there is no offense. Whatever it is. And they say it's rule under 40. Then it has to be a rule under 40. I may be wrong, but I want a clarification.
Hello.
Mr. Bora, if you get some time, just advise, just guide them also. Yeah. Mr. Monto, your matter.
From the evidence of PW2 and PW3, my lord, it's clear that there was a first affair on, my lord, the 5th. Because the PW2 is specifically in cross stated that after the incident, 2-3 days, the hazard was lost. Suppose the incident took place on 1-1, then, my lord, hazard must have been come on, my lord, 5th. And the doctor examination, my lord, it is on 5th. Without any, my lord, although they are saying...
Mr. Monto,
my lord,
you are here next week. You are here next week. Today, slight exhaustion. We will not have it. Because that 5-1 and 1-1, that we'll have to.
Yes, well.
Where is Mr. Goswami? You were looking at this. Mr. Borua was. Where is he?
And if it is suppose, well, suppose it's saying that the 2 hazard is there, then well, it is hit by the TT Anthony case.
Second one will be hit by one.
Second cannot be. Well, this is a violation of Article 21. Well, this I am clearly submitting. Well, as per the TT Anthony case that has been upheld in the.
No, there is no material to show that there is 2 FIR.
It is on the contents of
it is 1 and 5. Why that 4 days?
1 and 5, but hazard has lost on 10 too.
No, forget it.
Yes.
1 on first
incident. So for the incident.
So if there is a Mr. Goswami, where is Mr. Borua? 1, the thing is, 1 they said that they took him to the what do you call that, police station. So if it is 1 on police station, forget an FIR, there has to be at least a Huh?
That cannot be examined on fifth.
No. There has to be a GD entry on that
Yes,
day.
yes, definitely. Everything will be there. My submission is that when some the contention of the evidence and all the affair, it is clear that there is a two affair.
That you
Otherwise-
have not projected.
Projected, but this is the final facts, whatever is in our hand. This is clear from this.
But here also in the record, I find only one FIR.
The affair is the one.
But
But
I'm
what about
searching
the-
whether there was a GD entry made on that day and then
Incident, my lord, about the that is happening on 1-1 or maybe at 2-1. What about that? That is nothing is there in record to show.
a day, Learned Counsel for
Cannot
the
be a
parties
cloud is what
requested
the entire
to
issue.
discuss this matter again on Wednesday. Top of the list.
Possible, sir.
This will require some application of.
Yes, yes. It's the next Wednesday, my lord.
Mr. Barbuya,
Well,
we
then-
fix a date, we give it.
My lord, Wednesday, that can be, my lord, prepone or my lord, postpone. Because
Tuesday,
on the Thursday, my lord,
Thursday, no problem.
Wednesday is not possible.
Thursday. Tell Mr. Borua also. Yes, madam. 11 notes.
Not 11 notes, my lord.
11 notes.
No, my lord. This is the allegation. This is the
Recovery 11 notes.
They have shown 11 notes, but whether it is recovered from my position.
What is the material to show that it was not recovered from your position?
Because my lord,
How do you say that?
but my lord, seizure list is there. But in the seizure list, if anything seized from my position, that it was their duty to obtain my signature over there. That is not there. In both the seizure list. And the seizure list prepared not at the
Who is
spot.
appearing, Mr. Soma, Mr. Goswami? You appear.
And
Yes.
and His Lordship, from the this seizure was not made at the spot, Lordship. They brought to the police station. There is no corroboration regarding showing the notes by whom. They have not mentioned the name of the appellants also. If one say that accused Khajumiya, name also not mentioned. But if one say
Mr. Mahmood, what are you waiting for? Oh, that one. Okay, fine. But today, writ petition. Mr. Mahmood, I'm sorry. With this, it will be difficult today. You can give me a date whenever you want it. Whenever you want it. Because finishing this criminal matter, old matters will take some more time. And now Ms. Nagis is there, so I don't know how long she is going to take. When it will be convenient to you? After vacations? Heard Mr. M.E. Mahmood, Learned Counsel for the petitioner. So, also heard the additional public prosecutor appearing for this day, as agreed to by the parties, registry to list this matter immediately after the ensuing summer vacation. The matter be not treated as parted and or tied up with matter with this court any further. I'm sorry. I have to, because now I am with this. Now it is 326, 324 and all those things. I know. Anyway, we'll see. Yes.
But it
Hey,
is-
record to go to sir. No, it's okay. Yes.
My lord, in this case, as many as 8 witnesses examined, including the IO and the expert, that is PW5. So, my lord, PW1 is the informant, who is the shopkeeper of mobile shop, and others are the seizure witnesses of seizure list. 2 seizure lists were prepared in this case.
What is the name? More
My lord,
Bazaar mobile or dukan ase. You can read.
Dulal Das is the PW1. His shop was at Bazaar, Lordship, market. So then what happened, Lordship? These are the witnesses.
Okay. You. I know. I've seen it. But what is your point with regard to one? Start demolishing one by one. Start with PW1.
Kindly peruse the FIRs.
Okay.
In FIR, though, the date of occurrence is lordship on 24/7/2011.
FIR is there on with your appeal
Next
memo.
day. Next
Appeal
day.
memo.
My lord,
It's in the appeal memo or in the records?
record lord. Appeal memo only we have filed the grounds.
Just oh,
The interception was made on lordship on 25 as per information lordship on 24/7/2011. But the FIR was lodged on the next day.
how do you say that?
Lordship.
How do you say it was lodged on the
It is mentioned in the FIR lordship.
in the top portion, right hand
Yes,
side?
yes.
That is the date when the Chief Judicial Magistrate has seen it.
On that day, it is admitted by the PW1.
To 25/7/2011 is the date when the FIR was lodged.
Yes, but the occurrence is 24/7.
Okay. 24/7. ইংৰাজী 21 তাৰিখে দিনত প্ৰায়
Yes.
12 বজাত so 1000 টকা. Okay, let us now.
Then the FIR did not disclose the name of any of the accused person. lordship. Only he has stated only 1,000 not provided to him. And in the instant case, case is registered under section 489B and 489C. Regarding the there of fake currency lordship. So to step.
There are two Caesar list or one Caesar.
List one from the accused appellant lordship Khajumia and one from the Mazeda Begum. Two appellants are involved, two appeals are involved in this case, lordship.
Same offense, same judgment.
Out of same judgment, lordship. So
Okay, what is PW? What do you have to say about PW1?
lordship, we could go to the PW one by one. PW1 is informant, lordship. Where it was.
Yeah.
Is in vernacular language lordship. More Mayang Bazarat mobile phone dokan ase. Ajir pora pray 1 বছৰ আগে দিনত 10টা 11মান বজাত মই মোৰ দোকানত থাকোতে ডকত থকা আসামী খাজুমিয়া আৰু মাজেদা বেগমে মোৰ দোকান মোবাইল কিনিব আহিছিল তেওঁলোকে মোৰ দোকানত পৰা 1500 টকীয়া মোবাইল এটা কিনি মোক 1000 টকীয়া দুখন নোট ইয়াৰ মূল্য হিচাপে দিয়ে নোট দুখন সন্দেহ হোৱাত মই ওচৰৰ লোকগণক দেখুৱাও আৰু মায়াং থানাৰ পুলিচ আহি আসামীগণক ধৰে আৰু আসামীগণক খানা তালাচ কৰি পুলিচে মুঠ 1000 টকীয়া নোট জব্দ কৰে দেন এক্সিবিট দেন ক্ৰছ ঘটনাৰ দিনা not readable lordship মই 1000 দিও ঘটনা পিছদিনা মই 1000 দিও পুলিচে আৰু আসামী গণক নিয়াৰ পিছত মই 1000 দিও মই থানাত খবৰ দিয়া নাছিলো পুলিচ অহাৰ সময়ত মোৰ দোকানত 10-15 জন গ্ৰাহক আছিল গ্ৰাহক কেইজনে মই চিনি নাপাও নোট কেখন জব্দ কৰাৰ সময়ত মই দোকানৰ ভিতৰত আছিলো পুলিচ অহাৰ সময়ত মোৰ দোকানৰ ভিতৰত মই দোকানৰ ভিতৰত আছিলো দুখন নোটৰ বাহিৰে বাকি নোটবোৰ কাৰ পৰা জব্দ কৰিছিল মই দেখা নাছিলো ইজ ভেৰি ইম্পৰ্টেন্ট মাই লৰ্ড আসামী খাজুমিয়া মোৰ আগৰ চিনাকি মোৰ পৰা আসামীয়ে দিয়া নোট দুখন পুলিচে জব্দ কৰে thereafter denied then PW2 lordship
So what we understand from PW1 is that barring those two notes, the others we don't know. Two notes agreed.
no not agreed
Two notes by
he has
PW.
stated but
That's what I'm saying.
That-
Mr. I'm not
Yes.
asking you to make a confession.
yes
I'm saying from PW1, this court will
Yes.
also have to understand. Na?
yes lordship.
We're starting off to learn.
No,
So
no.
as far as PW1 is concerned, two notes, 1,000 rupee denomination, was recovered from the accused. That is, that he says.
That is the deposition of the PW
I'm
one.
not saying you are saying. PW1 is saying.
Deposition is like.
So as far as two notes are concerned, there is some material here from
That is
PW1.
there.
Ah,
But
then
Lordship, here, one more thing is that materially exhibited to 1 to 11.
Hmm?
Materially exhibited before the trial court, 1 to 11. It is in the last two lines, Lordship. Exhibit 2, Jabdonama. Pragya 2, Jabdonama. Then Bostu Pradorshok, Ekor Pra, 11 লৈকে, Jal note. First page. Last.
okay, fine.
Then he has stated that other notes were recovered from whom, from where, he did not know. So, Lordship, thereafter, others are hearsay witnesses also.
Yes, then
Then PW 2 is one of the seizure witness, my lord. Is one of the seizure witness of seizure list. The notes recovered, allegedly recovered from Mazeda Begum. Married, Lordship. I know the complainant Dulal Das. He is having shop house at Mayang Bazaar in front of my shop house. About 2 years ago, at about 12 noon, there was hue and cry in the shop house of Dulal Das in respect of paying the cost of a mobile handset by forced currency notes. On hearing hue and cry, I came to shop house of Dulal Das and came to know that the accused present in the dock today paid forced currency note to Dulal Das. So matter was informed at Mayang police. The Mayang PS police and came and seized the forgery notes of the denomination of.
okay, he says 4-5 notes.
Cross is also required. So thereafter, materially exhibited here 1 to 4. So he has not stated from whom it was seized. I put my signature by exhibit 3-1 at the PS. I did not see from whom seized material exhibit was recovered. Material exhibit was shown to me at police station. Not at the spot. From their position, these notes were recovered. So then what happened, Lordship? A distance between my shop and the shop of Dulal.
Get it, we got it. PW2 also gone. PW3.
And then one more important thing he has stated. Material exhibits cannot be recognized ordinarily as genuine. It seems to be genuine in its outer look.
No, that is for the forensic to say.
Forensic he has stated that.
Come to P3.
Come to?
PW3.
I know the complainant Dulal Das.
You can have suspected so and so. You can come to 1, 2, 3, 4, 5, 6, 7 line. So matter was informed at Mayang.
Yes. The notes of denomination so and so in number 1011 numbers.
In my presence.
In my presence, but materially exhibited 1 to 4.
1 to 4 is you come to the scissor list now.
Before that cross is needed.
Let us understand, madam. Come to the scissor list.
Scissor list, Lordship. 2 scissor lists were there, madam. One in the name of Khajumiya and other one in the name of Mazeda Begum.
This is
But my
Khajumiya.
lord, see the
Khajumiya is 7 notes.
7 notes.
And the wife is
Mazda.
4 notes.
Mazeda Begum.
4 notes, right?
Yes.
Okay.
That is as per scissor list. But the original, kindly see the original scissor list which is exhibited before the court. As per that exhibit, Lordship, there is no signature obtained from
Exhibit 2.
Exhibit 2 and 3. Both. In both.
That we'll take it up when you make your submissions. Now let us see the,
My lord, if anything recovered from, if any, suppose if the court master handed over something to me, then it was the duty to receive these things, lordship. So that
she
is the same
might give
thing.
it to you in faith also.
No, no, no. The notes is not in faith, my lord. It's an allegation, my lord.
Faith, I said. She might give you a document in faith also.
If suppose it is the duty of the official lordship, because it's an allegation that in criminal law, if anything lordship seized, then from whom it was seized as part of CRPC lordship, it is the duty of the officer to obtain the signature about the document. So if not seized, then not obtain the signature, that means lordship, nothing recovered from my position.
Okay.
So then, my lord, here also he has stated in his cross that it seemed to be genuine in its outer look. Accused person, that is another thing, lordship. Then what happened in regards to PWT Ranjan Nath. Ranjan Nath is or his signature in the Caesar list of Ranjan Nath for Mother Begum. In that Caesar list, his name is mentioned. So, my lord, here also stated that in notes of denomination rupees 1,000,
And
11 numbers
the Caesar of
1 to 4.
1 to 4, that is Majeda. Caesar of that from
Stated from Mazda, it was recovered.
oh, we can see, we can collaborate it with the Caesar list.
Yes.
1 to 4. And if you come to PW4, he is the Caesar witness of the recovery made from 7 notes.
But also whether these witnesses stated that from Mazda 4 notes recovered and from the other appellant recovered 7 numbers of notes.
Okay, we'll examine that. Now these notes are numbered. Notes are all numbered. The Caesar list.
PW 5 has stated.
5, he has then examined the numbers, and then he has.
See, my lord, PW 4. Cross. Police obtained my signature at PS to become a witness on a blank piece of paper. This is the status of the Caesar witness lodging.
Okay.
So, my lord, PW 5, she has stated that she is expert and examined the notes, whatever sent to the FSL. Because of this, in opinion, she has stated that examination reveals absence of interclio or printing process, absence of optical variable ink, and blue to green numeral 1000 in middle of the note, and also at the security thread, defective security, that they have explained, lordship, how the opinion they have made regarding that. And in cross, nothing there, lordship. But IO PW6 is one of the person who also not visited the place of occurrence where the accused person first made. First made by the PW1. He has come to the PS and he has stated that whatever heard from the PW1, he has stated before this, it is admitted in his cross. Then PW7, he has stated only 100 rupees note. 100 rupees not sent to the, not seized and not sent to the forensic also. So then thereafter PW8. PW8 is the IO. IOCs holder things at the PS before lodging the FIR on the basis of the GD entry. So he has stated that first on the basis of everything, he has recorded statement of PW1 and then seized the notes, and thereafter on the next day, this FIR was lodged. And he has admitted in his cross that, my lord, he has not obtained the signature of the accused person in the Caesar list, exhibit 2 and 3, although forged notes were seized from the position. That is admitted, my lord. So in this case, my lord, to establish the case under section 489B and 489C, lordship, it is the duty of the prosecution to establish that lordship, whether there is any mens rea or they use these notes as genuine or not, Lordship? Only recovery or possession is not sufficient to establish a case under 489B and C.
Okay.
So here,
Your submission basically is that the Caesar list cannot be the conclusive proof of the recovery of the notes from your possession, either of the appellants. Then second is the evidence by one of the Caesar witnesses that the signature was obtained on blank paper.
and hold the seizure at the police station, not at the spot. And one more thing is that PW1 has not clarified which note was provided to him. That number he has not specifically mentioned. This note was provided the accused person to me, and this I suspected that it is a forged note. So that was not placed or not identified by the
The statement of PW7 is that he's a grocery shop owner. PW7.
No, PW7 is LIC, is work under, LIC agent, he is LIC work under tax officer. Ah. Near the market.
There was some grocery owner who had 100 rupees, sold 100 rupees thing to you. PW8, sorry. PW8. 100 rupees was sold. He gave you 1,000 rupees.
PW7, my lord, PW8 is IO.
PW8 is IO.
100 rupees, whether 100 rupees seized by the investigating officer or in this case.
There was somewhere, I just found that.
100 rupees is not seized.
No. 100 rupees was not that you made a submission that 100 rupees was not shit. 100 rupees was never given. 1,000 was given.
No.
But on a doubt being created, that was not received.
I'll kindly see that line. I have one grocery shop at Mayang
That is it. PW7.
for marketing into my shop, and after purchasing some articles amounting to 100 rupees. 100 rupees.
Amounting to 100 rupees. Read further.
Yes, amounted to 100 rupees. So whether 100 rupees seized.
Oh, madam, you read further.
বস্তু কিনিছে
100 টকাৰ আনুমানিক বস্তু কিনা হৈছে. You read the vernacular.
Accused along with the others went for marketing into my shop, and after purchasing some articles amounting to 100 rupees, offered a payment of 1,000 rupees, one
1,000
note. But there, which note, my lord?
He did not accept it.
So which note?
Madam, you read further.
He has to identify that thing.
Madam, Nagis,
Yes, he has not accepted. But thing is that he has to identify the note. And there should be a mention.
Mr. Sharma, what is your?
My lord, PWD8, my lord, IO is categorically said, my lord, that 7 numbers from my lord.
See, there are,
And my lord,
forget it. The notes that were there,
Yes.
FSL report,
Yes.
it is proved. But now connect the notes to the petitioners.
But my lord, that
Sorry, the appellate.
that was not raised in cross, my lord. My lord, only he admit, my lord, that signature was not taken.
Very casual.
Signature was not taken, but my lord,
No, what is the effect of the signature not being taken?
that is my lord.
Fatal. That is fatal.
That is a my lord mistake. But my lord,
Not a mistake.
Yes.
It will go to disproof.
But my lord,
Now show me the evidence.
Yes, my lord.
Show me the evidence that number office note number so and so was recovered from appellant number 1, and note number so and so was recovered from appellant number 2. Nothing.
My lord, when my lord objection was raised by the PW1, my lord, police was informed, police came, and police seized, my lord, from both of them. And my lord, the numbers was also, my lord,
No,
categorically.
I can understand.
Yes.
Madam Nargis is there, so she don't say this. So they were afraid they said this, but unfortunately that is on record now. And in a blank paper, a Caesar list was thereafter incorporated. This is all done by her, but can't help it today. It is on record. So how do you? This too. Others, you show me this too, others will take care. Caesar witness, accused, note, connected. When?
I have to go through again.
When?
Monday, my lord? Not my lord, Tuesday.
Tuesday board hoyese na?
Tuesday, I only.
Have some sympathy for this court also.
My lord, sorry, my lord.
Wednesday.
Wednesday, my lord.
Wednesday.
That is on my lord, then it is my lord 24.
Why not make it Thursday, lordship?
There are only 2 days left.
2 days.
I have piled up also now. As agreed to, heard the Learned Council for the parties at some length, has agreed to by the Learned Council for the parties, registry to list this matter again on Thursday, Wednesday.
It is on
And madam, if you have any decisions on
Yes,
that,
sir.
24.
I'm highlighting this, lord, I'm giving.
you put it in the file. File of
Yes,
Twiddler.
yes, yes. Please.
Hmm. This would, I think, be the last matter. Any urgency, Mr. Alam? Madam, woman.
Item for hearing, item number 34. Since last 2 years, it has been listed for hearing, lordship. Maybe immediately after the vacation.
Oh, I thought that you will make a prayer that you want it today. That is the
Immediately after
urgency.
the vacation, lordship. It's almost 4.
I'm sorry, I've not read it. What is the issue?
Issue is appeal against acquittal, lordship.
Oh,
Criminal appeal against acquittal.
charge?
Enact case. Enact
NI.
case.
Oh, that can wait.
And come for the complainant.
34. After vacations.
21 is part hard better, lordship. It be 6.
No, if there is a part, we'll see today.
Vacation, okay?
$22 matter. It is that enact
NGO was not.
NGO. The same after vacation. Yes, madam.
Yesterday, I have filed an affidavit in
That, who's I? Registry to list this matter on Monday before the appropriate bench. So, matter be not treated as parted and or tied up matter with this court any further. Because with this whole matters, I will not be able to. Then, oh, that you call for it. That will go into the. Oh, Elika, Miss MSP Bormon, Learned Counsel for the petitioner has submitted that an affidavit, rejoined affidavit, on behalf of the petitioners has been filed today, yesterday. Registry to tag the same, trace and tags the same along with the records of the case and list the matter again on Monday date 22 before the appropriate bench. Full stop. Matter be not treated as parted and or tied up matter with this court any further.
Only transportation.
That we had heard this matter. Why?
Contact with him because
That is no reason.
or Monday.
Lordship, today it was supposed to be. 2 days.
But
Final transfer.
Madam Paul, what do you want?
Monday then.
No. How much? So that you have to pay some money to her, or he has to pay some
No, Lordship, the problem is that,
Get them traveling.
traveling, pay him.
Lordship, the problem is that he is completely bedridden, Lordship. For the last 3 months, he is not in a. Also, how can he pay? Because from the learned family court has awarded 4,000.
He has got property. He has got
No, no,
property.
no property. Actually, he has got the joint property that is still now, it is not.
Then you
partition.
go Esmali Pata, ask him to kata, then sell it and then. pay.
It's the actioneer, not the Miyadi one.
Umbe,
the
Sonia
actioneer.
Mati.
The problem.
State, the proceed.
But the two cases are here. Kamru Metro.
Both the cases are now in a limbo. Oh,
Only the case is at Hadipur.
you are the wife? And the maintenance one? That he is attending.
As for the last 3 months could not happen. That's why like court has awarded 4,000 per month.
Amount has been given.
It's the interim order.
You have not complied with.
For the last 3 months, he could.
And
not
what is the stage of the DV case? When it, before it was
Just-
kept in
just the-
animation?
Cognition only it is taken and then notice the petitioner and then this.
That's all, I'll do. How old is your client?
31 years.
Only.
Forty years. Oh, sure. Yes. And then Lordship, he is completely bedridden.